Hi everyone, I am Sam Gagnon, the Law Review's Symposium editor. Thank you for signing in today. The St. John's Law Review is thrilled to have you. As you know, we are here to commemorate the 100th anniversary of the 19th Amendment, which states very simply, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. The right to vote is one of the most important political rights in this country, but for most, it has also been one of the hardest won rights. For 244 years, American women were denied this right and thus prevented from participating fully and equally in our supposed democracy. But just under 100 years ago, as the result of tremendous strength and sacrifice, the first women in America exercised their newly secured constitutional right to vote. Of course, the story of women's suffrage does not end there. Asian Americans could not become citizens, so they could not vote until 1952. Black women who built this country and Native Americans whose land we live on could not vote until 1965. This was only 55 years ago. And still today, because of felony disenfranchisement and burdensome election laws, millions of Americans are unable to vote. The racial and ethnic disparities seen in women's fight for voting rights is emblematic of most gender issues we have faced and continue to face in this country. That is, in white women's pursuit of equality, we have weaponized our whiteness to ignore, endorse, and participate in the oppression of women of color, making the disparities among women often worse than those among different genders. This country has come a long way in the past 100 years, but our work is far from over. For starters, the United States is currently ranked 53rd in the world for overall gender equality by the World Economic Forum. We are ranked 76th in terms of women's representation in government. Our current Congress is the most diverse in our history, and yet less than 25% of our congressional representatives are women, less than 5% are Black women, and less than 3% are Latina or Hispanic women. Despite federal legislation outlawing discriminatory pay practices, women still earn less than men for doing the same work. For every dollar a white man earns, a white woman earns 79 cents, a Black woman earns 62 cents, and a Latina or Hispanic woman earns just 54 cents. And when it comes to maternal mortality, we are ranked 55th in the world, a shameful fact for one of the world's wealthiest countries. Even more shameful, though, is that the maternal mortality rate for Black women is more than twice that for white women. Deciding which statistics to cite today made my stomach churn, because it was a harsh reminder that the topics we will explore this morning are only the tip of the iceberg. But it was also a necessary reminder that we cannot move forward in the fight for equality without reevaluating how we've gotten to where we are today, or we will continue to leave most women behind. Remedying gender inequality in this country is no small task, which is not surprising when you consider that the systems on which this country was founded were built without the input of women. But I have hope, and I think that you should too, in no small part because of the community that has gathered here today. Here with us, we have both a group of legal scholars who have committed their time and expertise to exploring solutions to these difficult issues, and all of you who have taken the time to learn, grow, and hopefully act. So thank you. Thank you all again for coming. We have a great day planned for you. And to kick things off, I'm going to toss the mic over to the Law Review's Editor-in-Chief, Kim Computer.
Pleasure to be here with you all today, albeit virtually. I'll be speaking very briefly, and I have just a few points that I want to share. First, It is an honor to be part of an organization that is hosting such an important and timely event. At this symposium today, we are given the chance to commemorate the 100th anniversary of the 19th Amendment in the year of a presidential election, and we are also given the chance to explore women's rights in the United States in a year where we have been reminded time and time again of the inequities that still exist, unfortunately, in our country. I anticipate that throughout the day, we will have the opportunity to honor the past, look with honesty at the present, and turn with hope toward the future. Second, on behalf of the St. John's Law Review, I would like to extend our gratitude to all those who have supported this symposium. Thanks to Wilmuth, Maher & Deutsch, LLP, and David Wilmuth, a partner at WMD and a St. John's Law alumnus, for the generous support that made this symposium possible. And thank you to Rosalind Hallinan, an associate at WMD and a St. John's Law alumna, for all of her assistance throughout this process. Additionally, we are extremely grateful to all of the student organizations that have co-sponsored this event. They include the Children's Rights Society, the Coalition for Social Justice, the Dispute Resolution Society, the Federal Bar Association, Health Law Society, the New York Historical Society, the Labor Relations and Employment Law Society, the Latin American Law Student Association, the Multilingual Legal Advocates, the Palestino Child Advocacy Institute, the South Asian Law Student Association, the Student Bar Association, the Transforming Justice Initiative, and the Women's Law Society. Thank you all for promoting this event to your respective memberships. We also are very thankful to the law school and its administrators and professors for their encouragement, and we are extremely appreciative of all the panelists, speakers, moderators, and presenters who will be speaking to us today. Finally, thank you to everyone on the Law Review who has helped with our symposium behind the scenes, especially Sarah Catterson, Matt Dean, and our 2L staff member volunteers. And last, but by no means least, I would like to thank Sam. None of this would be possible. Thank you for all of your dedication and hard work in putting this together. You have the Law Reviews and my endless gratitude. I'm very much looking forward to the official start of this symposium. Thank you everyone for coming, and I hope you all have an enriching and enjoyable day. And now it's my pleasure to turn the mic over to Dean of the Law School, Michael Simons.
Thank you, Kim, and welcome everyone, and thank you, Sam. So the timing of this symposium is very apt, right? Not only are we celebrating the 100th anniversary of the 19th Amendment, but we find ourselves in the midst of a vitally important election, and one in which the vote of women will be defining. I woke up this morning and saw there will be an article in the New York Times Magazine this weekend titled, "What if only white men voted?" And if anyone who follows disaggregated polls knows about the gender gap in voting patterns, but this article lays out what actually would have happened in recent elections and future elections if only white men had the vote. And to see that alternative world laid out in detail was striking. We would have had Senator Roy Moore, likely Senator David Duke, almost certainly 4 more years of President Trump, and much, much more. And it's a reminder that the 19th Amendment was not only critical in advancing women's rights, but critical in allowing us to define the soul of our nation in a fundamentally different way. And so now is the perfect time to both celebrate what the 19th Amendment has accomplished, while critically examining all of the ways in which we still fail at achieving gender equity. And I'm really proud that the St. John's Law community can play a role in bringing about this conversation. Now, pulling off an event like this is a team effort, and there is much thanks and gratitude to go around. I want to reiterate what Kim said about our sponsor, Wilmuth, Maher & Deutsch, Dave Wilmuth, who wrote the check, and Rose Hallinan from the class of 2014, who made that happen. I want to thank my faculty colleagues who are behind this, Rosemary Salamone, Cheryl Wade, Edie Ward, and Catherine Durier, and all the law review students who've worked so hard to pull this off. Thank you. I just want to wrap up by highlighting 2 other things that really make me proud. First, you may wonder for those who are not part of the St. John's Law community, why there are so many co-sponsors for this event. I think Kim rattled off 14 co-sponsoring student organizations. That collaboration among our students, supporting each other around a shared agenda, is frankly one of the things that defines St. John's Law right now. It grows directly out of our response and our students' response to the killing of George Floyd. And it goes far deeper than just co-sponsoring events. It's a key part of the law school's growing anti-racism agenda, and it's a part of our culture that I'm particularly proud of. And second, while there are many people responsible for conceiving, planning, and implementing this symposium, I want to single out one of them right here at the beginning, just as Kim did. Sam Gagnon has been the driving force, and as everyone involved can attest, she is organized, diligent, responsible, and very much on top of things. And so, yes, many other people are also responsible for making today happen, but Sam deserves the lion's share of the credit. And she also exemplifies what is so great about our students, and that makes me very proud. And so I'm pleased to hand things back over to our host for the day. Thank you, Sam, and take it away.
Thank you both. That was a lot of warm and fuzzies for the morning. I am going to now put both in the attendee slot so you can sit back and enjoy the day.
I'll see you this afternoon.
See you later. All right, everyone. So I am now going to bring up our first panel, Professors Gomez, Johnson, and Havard, along with our moderator, Professor Salamone. And while I am doing that, I am going to tell you that there are going to be two little, sorry, I can't do two things at once. So first I will tell you two logistical things. I am going to put the program into the chat box so that you can follow along with the agenda and with the panelists and speakers' bios and their presentation topics. And the second thing is, during the panels and during our keynote speakers talk, I encourage you to put as many questions as you would like in the chat box. And then at the end of each panelist and at the end of the talk, the speakers will have an opportunity to answer, hopefully, most of your questions. So now I will bring up our panelists. One moment, please, everyone. Okay, Professors Salamone, Johnson, Havard, and Gomez, could you turn on your cameras, please? Excellent. Thank you, everyone. So now it is my absolute honor to introduce the moderator of our first panel, Professor Rosemary Salamone. Professor Rosemary Salamone is the Kenneth Wang Professor of Law at St. John's. She teaches constitutional law, administrative law, and seminars on comparative equality and anti-discrimination law and children in the law. Prior to joining St. John's, she was an associate professor at the Harvard Graduate School of Education and has lectured internationally and published extensively on education law and policy and children's rights from the comparative perspective. Professor Salamone, I now hand it off to you.
Thank you so much, Sam. I too join the chorus of thanking Sam for putting this together. She has been a stalwart promoter of this symposium from the very beginning. Without her efforts, this would not have happened. And so thank you, Sam. Planning for this symposium started over a year ago. And at that time, we perhaps rather naively believed that this would be the year of the woman, that 2020 would be the year of celebrating women and the women's right to vote. In fact, we planned several events around that year, but the year took off, as all of you know, in a very unanticipated way. And so this is the sole event that we were able to transfer over into a virtual format. As you know, the world this year changed in dramatic ways. We've had a world pandemic that upended life for all of us. We've had tragic deaths leading to Black Lives Matter protests and more focus, not just nationally, but globally, on issues of racial injustice. And more recently, the passing of Justice Ruth Bader Ginsburg. And without Justice Ginsburg's hard work promoting gender equality for women, I'm not sure most of us would be here today. I cannot believe that these developments, as I look back over this year, I cannot believe that they're not hovering over this symposium and will shape somehow how we examine the questions presented. And so with that, I'm going to introduce our first panel of presenters. Each of them is going to speak for 15 minutes. And what I'm going to do is hold off the Q&A until the end of the three speakers, and then we'll open it up to our virtual audience. And I'll introduce the speakers, all of them at one time, and then they can just speak sequentially. Our first speaker is going to be Professor Alyssa Gomez. Alyssa Gomez is a clinical assistant professor at the University of Houston Law Center. And her talk is going to be the mismeasure of success. After Professor Gomez, we're going to hear from Professor Cassandra Jones-Havard. Professor Havard is a professor of law at the University of Baltimore School of Law. Her talk is going to focus on structural intersectionality and the economic rights of women. And then finally, we'll hear from Professor Kit Johnson, professor of law at the University of Oklahoma College of Law. Her talk is going to be Rising Up Without Pushing Down, Lessons Learned from the Suffragettes, Anti-Immigrant Rhetoric. And so I'm going to hand it over now to Professor Gomez.
Good morning. I'm so happy to be here. Sam, I don't know if you need to do something to make me able to share my slides, but if that's too difficult, I'm happy to have you run them. So just let me know.
Okay, if your share button is not lit up next to your start video, then I will go ahead and start sharing them right now.
If you can share them, that'd be great. It's there, but it's grayed out.
Perfect. I will start sharing.
Great. Well, good morning. I'll start by saying that the title of my talk today and of my article, The Mismeasure of Success, is of course not original to me, and I'll get to where it comes from, but it comes from a fantastic feminist scholar from the early 90s named Carol Tavris, and she coined the idea of the mismeasure of woman. And what that has to do with law, I'll talk about as we go through today, but I'll start by introducing myself. I joined the Academy 3 years ago, and before that, I was a commercial litigator in a big law firm, both as an associate and then made partner. And a year after I made partner, I left. I left my big law world and I went to work in legal aid. I ran a legal aid office for 6 years before coming, like I said, to the Academy. And the whole time that I was making those professional changes for myself as someone who had made partner at an AmLaw 50 law firm, I thought I was in the driver's seat, that I was the most liberated, right? Because I chose on my own behest to leave a big law firm after kind of showing them that I could do it. But our reflection, and especially recently in talking, in listening and thinking about our country and how oppression works and how you sometimes don't know it's happening while it's happening, I've really questioned whether I had much of a choice at all and how liberated that really was. Sam, if you could go to the next slide. So it turns out, of course, I am not alone, right? Everyone is familiar with these statistics that women make up typically almost half and sometimes more than half in certain years of incoming big law associate classes, just like we see at the law schools. We have large numbers of women that matriculate, but just 20% of women hang on to make it as equity partners at big firms. And I wasn't one of those. I was definitely a non-equity partner. And where does this data come from? It comes from a November 2019 study by the American Bar Association. And so it's less than a year old. And if you look back at their prior studies in prior decades, unfortunately, these numbers are essentially the same. They really haven't improved much over the decades. And why is that? Well, the ABA concludes that experienced women end up leaving the practice of law at big firms, at least in droves, because, quote, the stress and time needed to do it all. And I know many of the folks listening here know what that feels like. Just to add on to that, the ABA released earlier this spring an additional report on women of color leaving big law. And there are issues I don't even touch in this talk, mostly because it's not my own experience, that are more troubling even than these sort of global statistics, how much more difficult it is to be a woman of color in a big firm and sustain what is kind of a low grade racism all the time. So I just want to acknowledge that this doesn't go into that report, but there is a very new report about that that's worth looking at. So when I started doing this research, it was before COVID, right? So this was even before our world turned upside down in terms of having to not only have a job and manage a family or a personal life that doesn't include children, before we were all at home together. So it's changed. Sam, next slide. All right, so why do women end up leaving big law? Well, like we said, there's just too much stress on women's time. And when you compare that with men, it's really pretty impressive. The ABA surveyed folks in the top 500 law firms, and women survey respondents said that 54% of them said that they have the sole responsibility for arranging childcare, compared to 1% of the men. We are 54 times more likely to have to handle childcare, which makes it kind of difficult when what you're measured against in terms of success at a big law firm is time, right? Law firms value lawyers based on time, billable hours, and even once you surpass the sort of grunting billable hours of your early years, then you are responsible for bringing in business to generate other people's billable hours. So the measure of success is undoubtedly the billable hour, but if you're 54 times more likely than your male colleagues to have to handle childcare, that makes billable hours rather difficult. Same with 32% of women having to leave work if a childcare need arose, 20% of women sole responsibility to handle extracurricular activities of children. Looking at the male side, we're looking at 1% and 4%. The deck is sort of stacked. Sam, if you will go to the next slide. So what does the ABA propose? They say the solution to the demands on women's time or to retaining more women is for these big firms to set retention targets of women, monitor gender metrics, support more part-time and flex time policies. Many firms have that, but real support from the top by encouraging folks to use it. And then encouraging use of concierge services for childcare and errands. I have to say, just on a personal note, my firm had all of these things, but it doesn't work, and it hasn't worked. And these same things have been proposed for decades. And I posit that it doesn't work because the solutions are still using the male ideal as the yardstick for success. What are all of these proposed solutions trying to do? Go to the next slide, Sam. They're trying to make sure women can act like men. Now, I know I'm saying things that are traditional male and female roles, and I know that is not the representation of all the gender norms in our society. I don't mean to ignore that in any way, but focusing on sort of the traditional trouble with ascending in a big law firm, Part of the issue is that the solutions, again, are all trying to make women mold themselves to act like the men who started these firms, which were in large part 1950s men with women at home to take care of the family, and they sort of pretended that they didn't have a personal or family life. It was invisible at the firm. You are to look as though your entire life is dedicated to the firm and your clients, and nothing else matters. And that is why they say things in the ABA report like, oh, if women just would take advantage of concierge services, like pay someone to take care of your children and run errands for you so that you can look like the men who are successful. And the basis for that is a theory that is often called difference blindness. So there's a lot of literature about difference blindness in law firms, and it is a really incredible concept that law firms play fair by pretending that there are no differences among people and instead setting one solid metric that if you meet it, you can succeed, and if you don't, you don't. And that's sort of fair. If you're either up or out, but it's the same standard set for everyone, and so it seems fair. And I definitely used to ascribe to that same notion. I thought it was completely fair that I left the firm because I knew what the standard was. I knew it's not what I wanted to continue to meet, but no one was treating me wrong. No one was treating me unfairly. It's just that it didn't feel like a good fit. And so difference blindness feels really fair and just, and lawyers like that, including me, because what's the alternative? The alternative to difference blindness is a system where we have to pay attention to differences, and that's really hard to navigate and to manage. Sam, can you go to the next slide? Sam, can you advance it? All right. Yeah, go back. Yes. So I think another theory can help us here, which is called feminist standpoint theory. Many of you are probably familiar with that. I love this cartoon on the right where depending on what you're looking at, depending on your standpoint, is what you see. So if you're looking at an elephant close up, you may think you're looking at a tree, a snake, a rope, a wall, a spear. And so feminist standpoint theory is a kind of standpoint theory that says it matters whose shoes you're in. And instead of perhaps having a male yardstick saying that, you know, it is fair to hold up the billable hour and the generation of business as the way you can succeed, feminist standpoint theory asks us to challenge those notions by recognizing instead that there is they call it the ruling class, right? There are people in power who want to stay in power in every institution. And it's difficult to let go of that, not consciously, but sometimes unconsciously. You don't realize the limitations of your point of view. So feminist standpoint theory asks us to take the point of view of the woman in these situations and reassess whether we're looking at the right things to begin with. Sam, can you go to the next slide? So this is the book, and it was actually an article that became a book on which my talk is titled. And these are some great quotes from The Mismeasure of Woman, which came out nearly 20 years ago and was a psychology piece talking about how even doing medical or psychological tests with men as the litmus is leaving out an entire swath of our population. And that show me a woman who doesn't feel guilt and I'll show you a man is one of my favorite quotes. And yeah, it's a little male bashing there, but it's to make the point that because our systems measure success by male standards, women will almost always feel inadequate or guilty because we either lack the right stuff or we're not doing it right or something must be wrong. And instead, the alternative is that women actually don't need to be the same as men in order to strive for a world where we have equal opportunities. Next slide. What are some alternatives to the proposed solutions? All right, Sam, you're going to click and it's going to make some animations. Just click through a couple times. All right. I think we should not be setting retention targets. If it was women at the helm, I don't know that we would be measuring how many of us were retained. I think that would be the norm. Monitoring gender metrics makes sense, but supporting part-time and flex-time policies, part-time and flex-time policies are helpful, but they still hold as standard high billable hours. They still hold as standard pretending that you have no personal life and then erasing that from your professional role. And as many women report, once they take advantage of part-time or flex-time policies, they don't get the same kind of work assigned to them that they used to. They're viewed as second-class citizens and promotion is more difficult. And finally, I'd like to reject the notion that we should use concierge services for childcare and errands. That may work for some women, but it may not for others, and that needs to be okay. Sam, one more time. All right, so what if instead, I think some proposed possibilities would be, and there's lots of great literature on this too, what if we did away with the billable hour? What if we measured success instead in terms of results or client satisfaction? What if the value proposition to begin with was professional fulfillment, individual happiness, family life, and diversity? If those things were the measure of success instead of time, we might have a different system on our hands. We also could just start with a blank sheet of paper. And there are some women-owned firms that have done that. I'll end by saying that the COVID-19 pandemic may be upending all of this. And it gives us an opportunity to have a blank sheet of paper. Women at big firms are reporting more satisfaction now than ever by being able to work from home. And I think there's something to explore there. Last slide, Sam, and then I will wrap up. As mentioned before, we probably wouldn't be here without this gem, but she is famous, of course, for saying that she would only be satisfied when there are 9 women on the Supreme Court. And as everyone knows, the reaction has been gasps, because no one can imagine that when the tradition is male. And I think that's the way we also need to think about big law going forward. Thanks.
Professor Havard?
I am going to make sure Professor Havard's slides are up. One moment, please. And I actually may have just figured out Professor Havard, you may be able to share your slides now.
Oh, I think I can. You're right. Okay.
Professor Gomez, I'm sorry I didn't figure that out in time for you.
Just one second now. Let me find them. Okay, hold on. Okay, good.
Excellent. We can see them.
And let me play slideshow. There it is. Okay. Actually, Sam, it might be better if you share them. I just realized something. Sam?
Okay, yes, I can do that.
Okay, sorry. I just realized. So as soon as you put the first one up, I'll start.
I think you have to stop sharing in order for me to share.
Okay.
Oh, never mind. There we go.
Okay, great. Thank you. I also want to thank Sam. and the members of the St. John Law Review for commemorating this important moment in time, the 100th anniversary of the suffrage movement, and this opportunity to discuss the past, present, and future of women's rights. I am going to talk about structural, economic rights for women, and I look forward to your questions and answers afterwards. When thinking about the current state of gender economic equality, I think about, of course, who I am, who my sisters are, who my daughter is, and my nieces. We are Black women. We live at the intersection of sexism and racism. It also means that as women of color, our economic security is threatened. The superficially positive strides of gender equality continue to fail women of color 30 years after Kimberly Crenshaw initially framed the intersectional theory. So I will discuss how race impacts the gender gap and how it can be fixed. I'm sorry, the gender wage gap and how it can be fixed. So there is a gender wage gap, not just in this country, but frankly, across the world, as Sam mentioned in her opening statistics. Equal Pay Day, Sam, can you show that slide? Represents the date later in the year that the average woman must work in order to earn what the average man earned in the previous year, regardless of experience or job type. After accounting for hours worked, career field, education, and employment sector, the average white woman earned 80 cents for every dollar. An Equal Pay Day this year was March 31st, which was 3 days earlier than in 2019. But here's the stark reality. Next slide, please, Sam. For all women of color, equal pay was at least 4 months later. August 13th was Equal Pay Day for Black women this year. The average Black woman earned 68 cents and had to work an additional 7.5 months this year on top of the 12 months they worked last year just to make as much as their white, non-Hispanic male counterparts did in 2019. And as you can see, for Native American women, the date wasn't until October 1, an additional 10 months, and for Latino women, not until October 29. In fact, it hasn't even occurred yet, almost 11 months later, in order again to simply earn as much as white, non-Hispanic male counterparts. So for women of color, the depth of the underpayment relative to white men is just staggering. By one estimate, women of color lose out on roughly $1 million of income per year. In reality, the law continues to fail women of color due to numerous barriers that make it nearly impossible for her to exercise her civil rights. In addition to reforming law and remedies through litigation and compliance, we also need to focus on other social and cultural reforms to end the racial gender wage gap. While some may argue that centering the reform on women of color is divisive, I argue that it is the most inclusive, because addressing the concerns of the least privileged necessarily also addresses the concerns of those who are more advantaged without the same risk of some segments being left behind. So in this short talk, I want to make 3 points, and I know I have to do them pretty quickly. The first is to talk about the intersectionality framework and why it best evaluates the gendered effect of economic security. Examining that overlay of race and gender shows the interconnectedness of economic security to social welfare policies and how gender discrimination can exacerbate other forms of inequality. My second point is that the intersection of women of color and economic rights within the political sphere has not always accommodated the complex, nuanced understanding of the economic discrimination that we face. And this leads to my third point, which is that any reform of the gender wage gap must incorporate a racial perspective in order to specifically address the racial aspects of women in fair pay. Wage inequality for women of color is pervasive regardless of industry, level of education, or experience. And to do otherwise is to provide a solution only for women who are racially privileged. So let's talk briefly about intersectionality and how present laws actually don't help to solve the gender wage gap, the racial gender wage gap. We recognize that our country has been very slow in affirming those who are marginalized. It took 144 years after the country's founding to give women the right to vote. It took 43 years more until 1963 before federal legislation was passed to address wage inequality. And when President John Kennedy signed into law the Equal Pay Act, the idea was that it would be illegal to pay men and women working different salaries for similar work a different wage. And it was to affirm that women entering the workforce would find equality in their paychecks. At that time, women earned 60 cents on the dollar. But about a decade later, a study revealed that the wage gap was still there. And so then comes the Equal Rights Amendment Act in 1972, designed to guarantee equal rights to all American citizens, regardless of sex. But it's not a priority. And so it hasn't been passed by all states and has not become a part of our Constitution. Later was the Title VII of the Civil Rights Act of 1964, which created a framework that grew out of the civil rights movement to prohibit intentional discrimination because of race, color, national origin, religion, and sex. And under Title VII, employees can allege sex discrimination in compensation, as well as hiring, firing, and other terms of conditions of work, which the employee must approve was a result of discrimination. And then finally, in 2009, there was the Lilly Ledbetter Act to close the wage gap. But in fact, the picture has become even bleaker. And right now, it is anticipated that without reforms, the wage gender gap for the average white woman will not be closed before 2058. And so that makes it even longer for women of color. So why intersectionality? It is certainly the idea that the way power is clustered around certain categories, we need to identify people's particular values and the values that foster and create social hierarchies. As I mentioned earlier, Kimberly Crenshaw challenged discrimination remedies as mischaracterizing the legal and political structures of Black women in America. Black women can experience discrimination in ways that both are similar to and different from those experienced by white women and Black men. By narrowly confining the legal discrimination that Black women face as racism or sexism, our redress is limited. So race and gender result in a complex and interconnected inequity. In fact, throughout history, America has not treated alleged violations against white women and women of color the same. In general, race and sex discrimination claims are only half as likely to survive summary judgment as claims alleging a violation based on a single trait. So intersectional discrimination claims have become more common for women of color, but are still only half as likely to prevail. And it demonstrates that courts do not understand and recognize the importance of intersectionality. They do not know how to analyze the multifaceted issue. And some courts appear to even to be confused because they handle when they handle a simultaneous race and gender discrimination allegation because they choose one or the other. So to understand how the economic discrimination faced by women of color has not accommodated their needs, let's look back just very briefly at the domestic women's rights movement and at the civil rights movement in the United States. I contend that reviewing that history through the lens of political economics supports why women of color's economic rights must have a more nuanced remedy. There was the shared experience that women of color enjoyed during both the women's suffrage movement and the civil rights movement. shared experience, but it did not significantly advance their rights, and especially their economic rights. As we said earlier, the 19th Amendment supported granting voting rights to women, but African American women only achieved voting rights under the Civil Rights Act. And so this iconic struggle of the suffragists, white, middle class from the East Coast, looks as though it was a long-standing tradition that celebrated women's suffrage based on a single issue of gender. And so the political rights of Black women were felt to be threatening. And though they participated in the marches and in the demonstrations, again, their political nor economic rights were recognized. Similarly, African American women were invisible in some respects during the Civil Rights Movement. African American women, as well as African American men, marched and were prominent in dismantling the segregation of the Jim Crow era. But Black women did not share in specific benefits that were exclusive to their issues and concern, especially as marginalized workers in low-paid sectors. And so both of these movements sort of show why historically the participation of African American women in domestic movements may not address their political and economic needs. And so for that, I turn to the discipline of political economics, which unifies political science and economics as a unified subject. Now, don't get nervous. I'm not going to throw around a lot of economic terms. But I am going to say that what we need to understand is that even in making economic analyses, there are issues of power and equality and democracy, and that those ought to be at the center of any legal solution. And so when we think about the economic and political power that is visible in some respects right now in this country, when we see the election of Donald Trump and we see the Occupy Black Lives movement, there is really a renewed call to understand that law is not neutral, and that in the resolution of any legal dispute ought to be an understanding of the politics and the economic ramifications. And so in that way, the economic and political power become intertwined with racialized and gendered inequality and subordination. It also means that the intersection would allow others to hear the voices of women whose experiences are different from their own. So this is a more inclusive lens. It recognizes that all women don't experience income inequality in the same way. And so an intersectional approach would acknowledge the barriers faced by women of color who have, again, a more nuanced problem, but who risk being provided with a real solution if those barriers are not removed. And so I think that the reforms that need to be addressed are twofold. Certainly there are legal reforms, and then there are more policy reforms. So let's spend a few minutes on the legal reforms. When we think about Title VII, it puts all the burden on the employee in order to prove the claim. Another legislation to think about reforming would be the Equal Pay Act, because the Equal Pay Act gives plaintiffs a stronger advantage over Title VII. It is a burden shifting approach that once the plaintiff employee makes out a prima facie case, the defendant employee must disprove rather than the employee prove the discrimination. And so doing this while also giving standards for the intersection of gender and race, especially in economic cases, would help courts to understand how they are to ferret out these particular claims. And also would affirm that racialized gender equality is an important public interest. that it helps to root out unfair competition. It helps to balance employee and employer bargaining powers. And certainly it helps to improve the health and welfare of those women who are disadvantaged by low wages. The other reforms follow the model of what's being done in the European Union. And so in the European Union, there are reporting requirements that require transparency by companies. And companies have to report on all the significant factors. So they have to report on levels of experience and look at the career ladder in terms of other factors that make a difference in terms of the wage that women are paid. And by these reporting factors often result in a scorecard, and they put public pressure on companies to do things differently. Companies, of course, also need to be more vigilant in raising concerns about wage bias and making employees understand that it is in everyone's interest when there are equal opportunities for fair pay, and that all the talents that women of color bring to the table are being fully recognized. And so a change in the culture, a change in the law, a change in policy, all of these are important in addressing the pay inequity. And when the pay inequity issues are addressed, of course, it has ramifications not just for Black women and their families, but also, again, for the larger society, because it makes for a more sustainable economic base, and it makes for families being able to afford to do the things that they need to do in order to maintain their economic well-being. And so it's not enough to just ask for equal pay, because equal pay is not enough. We need to ask for these comparisons that would give Black women and women of color commensurate pay. Pay that's based, again, on their education level, work experience, network, and of course, the value that they bring to the table. Because the value that they bring to the table is substantial and it must be recognized. Thank you.
Thank you, Professor Havard, and thank you, Professor Gomez, as well. Having heard two presentations addressing very important and different issues, we now turn to Professor Johnson, who's going to give us a look at the issues of gender equality through yet another lens. Professor Johnson?
Thank you.
Professor Johnson, I think I just gave you the ability to share. Does that work?
You did.
Amazing.
I did not, however, get it quite set up right. Let's see if we can do that. Is that showing to you guys?
Yes.
Okay, terrific. I'm going to set a timer because I have a tendency to talk. So I want to make sure that I keep us on track here. I am going to be talking about something a little bit different today, which is to think a bit about the suffragists' anti-immigrant rhetoric and to talk about nativism in the context of the suffrage movement and think about its enduring appeal today, or at least in the modern era, and to end with a discussion about sort of lessons that we can learn from how much nativism influenced the early suffragists and to come up with a sort of new approach going forward. So I want to take us all the way back. We've been having these modern conversations about, current pay that people have and life in big law. And I'm going to take us all the way back to the first Women's Rights Convention held in Seneca Falls, New York, in July of 1848. And at Seneca Falls, the participants signed on to the Declaration of Sentiments. And one of the important phrases in the Declaration of Sentiments was, "We hold these truths to be self-evident, that all men and women are created equal." a little bit of a modern twist on that. I heard last night, I heard Biden say that during his portion of the debate, the men and women, and I was surprised because, of course, that's not how our Declaration of Independence reads. They wanted to add that all women. But what's interesting about that very first Women's Rights Convention is that the early suffragists really understood when they said all men and women, they did not mean it. And they certainly were not thrilled about immigrants. And so here we have Elizabeth Cady Stanton, a contemporaneous illustration of her speaking at the Women's Rights Convention in Seneca Falls. And she said, to have ignorant foreigners recognized, fully recognized, while we ourselves are thrust out from all the rights that belong to citizens, it is too grossly insulting to the dignity of women to be longer quietly submitted to. What was she talking about? What does it mean that ignorant foreigners were fully recognized at the time? What she was talking about was in the 1800s, alien suffrage existed in some 22 states and territories across the United States. That is to say, non-citizens who were living in the United States who were not yet naturalized were given the right to vote on a state-by-state and territory-by-territory basis. And the territories were doing this in large part because the federal government offered voting rights federally on the basis of settlement, granting representatives based on the number of free male inhabitants in a territory as opposed to natural-born or naturalized U.S. citizens. So in large swaths of the country in the early 1800s, non-citizens, immigrants, had a right to vote that women did not have. And to say that the suffragettes were peeved about this is a bit of an understatement. So one way in which the suffragettes sort of reacted to alien suffrage and their own disenfranchisement was to make arguments that are perhaps out of step with our current mode of thinking, but that are more argumentative as opposed to hateful. And I'm going to sort of talk about how they do both of those things. But let's, for now, just take as an example, one example of the kind of argumentative side of nativism. So the Una was a newspaper, as you can see here, if you look very closely, a paper dedicated to the elevation of women. So a women's newspaper that existed in Massachusetts in the early 1800s. And one thing, in one particular sort of op-ed about suffrage, the paper writes this, right? It would be a disgrace to our schools and our civil institutions for anyone to argue that a Massachusetts woman who has enjoyed the full advantage of all their culture is not as competent to form an opinion on civil matters as the illiterate foreigner landed but a few years before upon our shores, unable to read or write, by no means free from early prejudices, and little acquainted with our institutions. Yet such men are allowed to vote. So there was this argument that, hey, we'd be better. You're already giving these people the right to vote. We would be better than that. But it's not always about argumentation. There was a definite, strong underline of hate. So immigrant foreigner comes up a lot of times. An example would be the mass of ignorant immigrants who almost go from steerage to the polls, right? Really unpleasant stuff. And of course, the Civil War did not improve things. After the Civil War, Congress granted in the 14th Amendment the right of male citizens to vote and not women. And this led white educated female suffragists to sort of say, wait a minute here, you're giving the right to vote to not only these non-immigrants, but now you're giving it to former slaves and not us. And the language that came out was truly hateful. So this is Elizabeth Cady Stanton years later. So she earlier, you'll remember at the Women's Rights Convention saying, hey, we could do as good of a job. Later, she starts saying stuff that is truly appalling. Things like, think of Patrick, that would be the Irish immigrant, and Sambo, which is a really offensive term for the freed slaves, Hans, German, and Young Tongue, that's supposed to be about Chinese immigrants making the laws. So she wants people to think about these things, react against it, and give the women the vote. There was a lot more fuel for the fire as the suffragists continued more decades and into the World War I. And that's because in World War I, the entire country was sort of really gripped in an anti-German fervor. So here are two government posters. One is urging women to buy bonds in order to defeat Germans. And the one on the right is about warning people about the threats posed potentially by their German neighbors. And it's that latter kind of motive and argumentation that really worked in suffragists' favor during the very end of the suffragist movement. So here we have Anna Howard Shaw on the left and Carrie Chapman Catt on the right, both presidents at different times of the National American Women's Suffrage Association. And to give you a sense of how they used their concerns about this sort of national concern about Germans living in the United States to further their cause, Shaw said that giving women the right to vote would help eliminate the evil schemes of foreign traitors. And Catt herself talked about how we have slackers. Every slacker has a right to vote, every newly made citizen, every pro-German who cannot be trusted with any kind of war service, every conscientious objector, and even the alien enemy. This language, scholars believe, and I think is true without question, was a key component in actually getting the female suffrage, to getting the vote. It turned people out. This idea that women's suffrage would somehow combat the voting of illiterate, ignorant people who already had the vote, plus people who were not loyal to the United States who were given the right to vote. And so women were going to counteract both of those things. And these nativist anti-immigrant arguments really pushed that movement ahead. And if you're wondering, well, why did they use this, right? Why did they use nativism to make their argument? I think it's pretty clear they used it because it works, right? We know that nativism works. And so just some small examples from the modern era, we can look to California in the early 1990s, which was experiencing a really deep recession. And a group rose up saying, hey, we can solve things if we just eliminate any public services, hospitals, schools, education, anything related to undocumented migrants in the United States. And they created a proposition famously called Proposition 187, which was also, as we see here with one of the proponents of it, the writers, the Save Our State initiative. And the idea was we will save our state by saving it from the problems that undocumented migrants bring to the country. And all of the rhetoric surrounding the passage of this act was very much about being anti-immigrant, pro-America, and how we will move our country forward. So you can look at modern examples in terms of issue success. You can also look at modern examples in terms of personal success and in terms of party success. So as a quick note here, on the right, you have Chris Kobach, who in early 90s was a law professor and a relatively obscure guy. And now today, he is a nationally recognized leader on anti-immigration measures. And you can see his power in meeting with Trump. And of course, many on this meeting will remember that Donald Trump's 2016 campaign in particular really ran on strong nativist rhetoric. Ideas that we shouldn't have refugees coming into the United States anymore because they pose a threat to the United States, that we shouldn't have Muslims come to the United States anymore because they pose a threat to the United States. Undocumented immigrants are criminals and they steal social services and they are a real hindrance. And of course, his election paved the way for Republican domination of both the executive as the winner of that, the House and Senate, which they controlled for the first part of his election, and because of maintaining their control in the Senate, as we're all aware, and speaking about Ruth Bader Ginsburg, control over the judiciary and the judicial nomination process. And all of that, so much of that is owed to the nativist rhetoric that got the base so excited about voting for President Trump, then President Trump. So let me talk before I leave just a little bit about sort of how do we move forward, right? Things have changed dramatically since those early suffragists utilized their really divisive nativist rhetoric. And today there's a lot of strength and moral legitimacy in the women's movement based on their alliance with the immigrant rights movement, right? Seeing, this is just from their website, the National Organization of Women, right? Immigration as a feminist issue. As Professor Harvard said just a little bit ago, right? Thinking about the movement towards supporting workers has not excluded how to improve the situation of domestic workers who do not have status in the United States, for example. So we are moving in a positive direction, but it's easy to step back, and it's easy to step back. And one example I like to use is that of President Obama, who in 2014 talked about or created a system for expanding deferred action. So not going after people who are undocumented in the United States and giving them a pathway to sort of stay here legally and work for a little while. But in that speech, one of the things that he said was, and a really, really famous quote, "Felons, not families, criminals, not children, gang members, not a mom who's working hard to provide for her kids." And this, I think, is where we have someone who's trying to do something pretty liberal, right? Helping out folks who are undocumented, but still using this really divisive pushing down language. And maybe you're sitting there listening thinking, well, I don't want felons, like I just want to help families. But felons in the immigration context can be someone who has just come to the United States without authorization, left, and then returned again without authorization. That's a felony in the United States. And so someone could really be a mom who's working hard to protect her kids and still be a felon. And so I think we have to continuously reevaluate and think about how we can move forward without pushing down. And I think that that's not an easy task. And there's so much to do in terms of supporting immigrant women who right now have a harder time getting the opportunity to work, even if they are legally here in the United States. There's been tremendous damage done to immigrant women who've been victims of domestic violence, and eliminating any pathway that they might have towards getting asylum in the United States and safety and care. So there's a lot of things that we can do moving forward. And the final thing that I want to talk about, though, is to go back to the suffragettes. So we've talked about how the suffragettes' nativism is problematic, how it's understandable that they utilized it because it is something that works to promote issue success, personal success, party success. But what's a different way forward? And I find real inspiration in the slogan of the National Association of Colored Women, which was a suffrage movement in the late 1800s, who talked about lifting as we climb. And I think there can be no greater inspiration than to keep this concept in our heads as we move forward and think about a new way to make sure that we lift as we rise up instead of rising up by pushing people down as we go. Thank you very much.
Thank you, Professor Johnson. You have all raised a number of interesting thoughts and questions. I just want to make one observation, or perhaps it's a memory coming out of this. For those of us who attended law school, those of us women who attended law school in the 1970s, we very innocently perhaps thought that we were going to change the culture of the law firms, of big law and the practice of law. And, you know, as we see from what Professor Gomez is telling us, it's rather disheartening that it changed. Maybe it nibbled a bit around the edges of the male way of doing things, but it really hasn't changed enough. So we do have some questions in the chat box. The first is for Professor Gomez. How likely do you think it is that firms will actually do away with billable hours?
So I would say unlikely in the short term, right? There's some things that have to happen first. But the number one thing that affects law firms are clients. And as clients, like corporations, demand things, law firms deliver. So when corporations say it's really important to us that you have a diverse team on that trial or on that deal, law firms try to do that. That's where a lot of the pressure to retain women and people of color comes from. Some will say it's internal, but I think the more cynical, maybe more realistic view is that it comes from client pressure. And as women and people of color rise within the in-house legal departments, I think it filters into the law firms. And so that has happened with pro bono work, for example. So I think, billable hours are really important to the economics of law firms, but there are many alternative ways of doing things, like flat fees or partial billable hours and maybe a reward at the end depending on the outcome, but it's not fully contingent fee type work. And so I think it's I don't think it's immediate, but I think just like anything else, if you set an intention and set a goal and talk about it, like this is something that, it's untouchable in the big firm world, right? But I think if people start to float the idea as a way to retain women and diverse lawyers, because it sort of shifts what's valued. And if the clients start to mirror that language, I think it's possible.
Do you think it might come from a new generation of young lawyers coming into these firms? We talk about millennials and Generation X and Generation Y and how they see the world very differently.
Yeah, and I think lifestyle is extremely important to millennials and to Gen Z. And they, I don't know that they'll stand for it, right? Especially after COVID. And I think COVID's going to make it clear just how messy life actually is. I don't think it can stay invisible anymore when your kids like mine come and wave hello on all of your Zoom calls, or you have to leave because someone's crying because they can't figure out virtual learning. That it's literally happening and everyone's watching, and the men are involved, right, in a way that they weren't before. My husband is incredibly involved in our childcare, and being able to work at home right now is helping that. I have a friend who this guy has always traveled multiple times a week for 10 years. He's never been at home with his kids, and he's been literally grounded since March, and he's now discovered that he really likes it. And so I don't know that he will accept a job, that his job sends him across the country multiple times a week. And so I think as that, affects everyone, we have a chance.
Yeah, I keep thinking that our brains are being rewired as a result of the pandemic, and nobody knows what life is going to be like, what we're going to be like on the other side. There's a question for Professor Havard. Do you think Title VII could be amended to better address intersectional claims? Or do we need a whole new statutory framework?
Now, I'm not a constitutional law expert, okay? So I'm more in that corporate commercial law. But from the reading that I've done, it sounds like it might be better to have a new statutory framework, because part of what we want to do is to shift the burdens in a different way. And we also want to make it clear to courts what they have to do in terms of not segregating the claims and not choosing between one or the other. So certainly Title VII, possibly could be amended to do all of those things. But again, there's also the Equal Pay Act that's already there, or there is a Fair Pay Act that's been, I think it's out of the House committee, but it hasn't gone, very far in the bill passage process. So it might be time for some fresh eyes.
A question for Professor Johnson. How important is it to determine if the white suffragists were actually racist, or if they merely use the racist rhetoric dramatically? Is there any difference?
I think there is, and I've really been struggling with it. I've been writing my initial draft on this. Sort of took the idea that every time they said ignorant foreigner, it was very hateful. And then I'm now struggling with that a little bit more and wondering if it was more argument. But there's so much that we cannot get away from that is so very clearly hateful. And I think a lot comes post-Civil War. that post-Civil War, Elizabeth Cady Stanton was a suffragist. She was a suffragist. Not suffragist, I'm sorry, an abolitionist. She wanted to end slavery. She wanted to see the outcome that we got in the Civil War. And yet after it happens and Black men get to vote before her, her language turns in a way that's really, really distressing. And I think it's important to recognize that. I think it's part of what Professor Havard was talking about in terms of intersectionality, right? You have to recognize what they did.
These women were so much a product of their times. So do you think we should be somewhat forgiving or not?
I think in my thought is that I may be forgiving of the ignorant foreigner comments when phrased in the way that we saw in the language from the newspaper, the Una, where it's very much about, hey, you've already given them the vote. I'm not asking you to take it away. I'm saying I would be as good, if not a better voter because of my education and everything. I think that maybe we can understand as a product of their time. I think even at the time, at the time it happened, people understood that using the word Sambo was offensive and not okay. And I think that we have to, it's hard to see our heroes in such a negative light, but it's important, I think, to see that and really acknowledge it.
At the time, the nativist rhetoric was coming from the top. You had Woodrow Wilson, you had Theodore Roosevelt, making statements in the public and to the press that were really hair-raising from our perspective now. Just a note, I think we have to remember there was a time when an American citizen, a woman who was an American citizen, married an immigrant, an immigrant who had not yet naturalized, legally here, but had not yet naturalized, would lose her citizenship. Yes. And she would be a woman without a country. And I could say that personally because it was my grandmother who was a girl from New Jersey who married an Italian immigrant at the age of 16. And I believe her father must have said, either you become a citizen or I don't let you marry my daughter, because I think he became a citizen the day before the wedding, as I see his naturalization papers. We have a few more minutes. Do any of you, the panelists, have any questions or any other issues you'd like to raise? Any of you? What are you do mention undocumented women today. And that is, I think, a burning issue that people are just not aware of. We just don't think of. They're the women who are working in the healthcare industry, home aides, nannies, taking care of the children of working women, the women who are working in the law firms 80 hours a week. We have to think of who are the women who are really holding up the fort for them. And it seems to be an issue that is just, we're really not consciously aware of, or that women who talk about women's rights are not consciously aware of. Professor Johnson, since you spoke about the immigrant issue, do you want to address that a bit?
I think it is a really tough issue, in no small part because the effect on immigrant women is immigration law is so hard. So we can, in one sense, we can all say, if you're undocumented, meaning you have no papers and no authorization to be in the United States, you can fit into one category and we can deal with you and think about you. And I actually think that the women's movement has been better about that group, thinking about how do I organize domestic workers, for example, some really innovative, again, going back to Professor Harvard, the innovative corporate law structures, thinking about how can I use LLCs to kind of help women move ahead and stuff. I think what's hard is that immigration law has many, many facets. And so since women are immigrants of all kinds, they're affected by a bunch of different things. And so someone coming over as a domestic worker is going to be really different than someone who is seeking asylum. And so the changes that they see in terms of the law can be really dramatic. And it's hard to stay on top of all of that. You mentioned home healthcare aides. A huge percentage of home healthcare aides in the United States are in the United States on something called temporary protective status. That's something totally different, and it gives them authorization. And Donald Trump has really tried to pull that back, and there's a lot of current litigation. I think it can be very hard to be a feminist, someone working for women's rights, and be on top of all of that immigration stuff, because it is so varied. There's so much to it that even if we are aware that somebody is not a citizen, we may not be aware of what category they are in, and that category that they are in really dramatically affects the restrictions that they're facing, and then affects how any movement, any organization can support them.
A kind of final question about, and this maybe Professor Havitt or Professor Gomez could address it. Can you expand on how you think COVID-19 will affect law firm culture, especially when it's forcing women out of firms even more? Professor Gomez, maybe you could start.
Well, I think we touched on sort of the positives that could come out of it, but I know people are aware of the, some almost 900,000 women that left the workforce in the last quarter, and because of COVID and the need to take care of personal thing, just unable to do both. I don't know what that looks like, what that breaks down, for professional women or law firm women in particular versus just, women in the population generally. So I actually don't know the answer to that question. It could have, a negative effect where we go backwards a little bit, but I'm hopeful that depending on what happens in November and as we continue it over the next year plus, that maybe there will be, it'll be a minor setback and we'll rebound.
I'd like to add something. I think COVID is definitely, excuse me, showing how the makeup of our economy and labor force places women in some of the lowest paying jobs. And there are lots of women, of course, who have lost their wages because of the nature of their jobs and their businesses have closed. And so COVID has certainly protected women in certain classes. More so than it has protected, any of the lower wage hourly workers. So COVID also shows us the broken economic system. There are people now, of course, who are suffering because they are not paid, but also, even if they are paid, it might be, they have 2 part-time jobs and no insurance. So we just see all of the manifestations of a broken economic system that's not valuing workers and not valuing the labor that they provide for the economy and to keep it going. And I certainly hope that as we begin to see these things, we'll work to fix them.
Thank you. I promise, Sam, that I will try very hard to keep on schedule. I want to thank our 3 panelists today. You've all given us so many things to think about, so many avenues to take our thoughts and even our scholarship in writing in different directions. I look forward to reading your papers in the Law Review Symposium issue, and I'm going to hand it back now to Sam. Thank you all.
Yes, thank you. This was such a fantastic start. I am going to now direct us to a quick screen break so we can all get up and stretch our legs. I'm going to put the current panelists to attendee status, and when we come back at 11:37, so please be back at 11:37 or for the Central Time Zone, 10:37, we are going to have our keynote speaker, Professor Tanya Banks. So we will see you soon.
Oh, hey, Tanya.
Hey, Cheryl. Oh, hi.
I wasn't able to start my video at first.
Oh, please do not even talk to me about the date and whatever. I'm sitting here saying, I cannot be freaked out. I cannot. I hate WebEx. Okay.
Okay, well, here we are. Oh, my goodness. Hi, Sam.
Hello.
We're just in panelist mode. Nobody else can hear us, right, Sam?
No, everyone can hear us right now. So, but everyone's on a screen break. You're fine.
Okay.
For everyone that can't hear us, we're going to start in 2 minutes.
Oops. We'll talk later, Tanya.
We definitely. Well, yeah, and Rachel is supposed to be listening.
Hi, Rachel.
Well, I don't know if she, because she's in Central Time Zone, so who knows whether she got up, but I'll pretend that she's not listening, so because I get nervous.
Oh, okay. We better talk later, Tanya.
Okay. Yes. Oh, if you're still talking to me.
Well, I say we should talk later because Sam said other.
Oh, everybody. Yes. Right. Yes. Okay.
Even though they're supposed to be on a break, they're not supposed to be eavesdropping.
All right, everyone, I am going to keep us chugging along. So I'm so excited now. I am going to introduce Professor Sarah Wade, who is going to open it up for our keynote speaker. Professor Wade is the Dean Harold F. McNeese Professor of Law at St. John's. Prior to joining the faculty here, Professor Wade served on the faculty at Hofstra Law School and was a corporate associate at the law firm Paul Weiss, Rifkin, Wharton, and Garrison. She now teaches issues of race, gender, and law, which I'm currently taking, business organizations, corporate governance and accountability, and race and business. Professor Wade, I hand it over to you.
Thank you, Sam. Thank you for asking me to introduce today's keynote speaker. And I congratulate you, Sam, for this phenomenal work you've done in making this incredibly impressive symposium possible. By the way, Sam, I should tell you, I was on a Zoom call with Professor Banks when she received her St. John's swag bag that you had mailed to her. And I have to say, I was a little bit jealous, lots of good stuff in there. But I digress. It's my tremendous honor to introduce Tanya Banks, the Jacob A. France Professor of Equality Jurisprudence at the University of Maryland School of Law. Before becoming a law teacher, Professor Banks was a civil rights lawyer in Mississippi, where she litigated voting rights and housing discrimination cases, and also provided technical assistance to Black elected officials. Professor Banks also worked as a senior trial attorney for the Equal Employment Opportunity Commission in Los Angeles, litigating some of the early sexual harassment cases under the commission's then interim guidelines. When Professor Salamone talked with me about working with her, Professor Duryea, Professor Ward, Sam Gagnon, and the law review on this incredible event, I admit that I was a little reluctant, primarily because of time constraints, but I was hesitant also because I had read troubling work about racist comments by suffragettes like Elizabeth Cady Stanton. Professor Johnson mentioned her earlier in light of her anti-immigrant statement. And a statement by Susan B. Anthony that was dramatic in its racial insensitivity. And even though, as we've spoken about already at this symposium, even though African-American women played an important part in the fight for universal suffrage, they were more often than not met with disrespect. Just one example is that African-American women had to march separately from white women in suffrage parades. So I was concerned about where African-American women would fit into the narrative about the 19th Amendment and its commemoration a century later. I was concerned about the intersectionality issues about which Professor Havard spoke on today's first panel. So when Professor Salomon asked if I knew of someone who could speak to these issues, I thought immediately of Professor Banks. And this is why, as Dean Simon said earlier, I am so very proud to be part of this St. John's Law community, because I really had no reason for concern, in spite of experiences that I've had in other contexts. There was no reason for concern here. Because of my time constraints, I have to admit also that my only contribution to this event was to suggest Professor Banks for today's symposium. And Professor Ward said that was perfectly okay because that was such a huge contribution. Professor Banks is a renowned and enormously respected scholar. Her recent publications explore the continuing impact of gender, race, racial formation, and racial hierarchies on the quest for social equality. She is a contributing editor of a book, Screening Justice, the Cinema of Law, Films of Law, Order, and Social Justice. She has written a voluminous number of articles and book chapters on a wide variety of subjects, including colorism, post-racialism, gender, justice and cinema, and multiracialism. She has explored issues of justice in many interesting contexts. For example, she has written articles on medical research, and she has also written at least two articles, about legal issues in contexts that few consider. One article is entitled Toilets as a Feminist Issue, a True Story. And she wrote a 2020 article entitled The Disappearing Public Toilet. Professor Banks' well-rounded life as a scholar is reflected in the courses she teaches. She teaches courses on citizenship, law and identity, law and literature, law and film, and a seminar on economic justice, race, and markets. And Professor Banks lives a full personal life also. And here the observations of Professor Gomez are so very relevant. It has always been clear to me that Professor Banks' very rich professional life is not all about the law in her personal life. She is an avid consumer of the arts, opera, theater, dance. She's on the board of trustees for Center Stage, the State Theater of Maryland in Baltimore. She is the mother of two, a daughter and a son. She is a mother-in-law and a grandmother to an adorable little boy named Benjamin. And I'm very proud to say that she is my friend. Welcome, Professor Tanya Banks, to this St. John's Law Review event. We are so very fortunate that you have agreed to spend time with us and speak to us today. Thank you.
So, is it time for me to speak?
Yes.
Okay. Well, I don't know. I mean, that is the most tremendous introduction I have got. It helps to have a friend introduce you, but that's a fabulous thing. I'm not sure that I can live up to this build. But nevertheless, I want to thank you and the members of the St. John's Law Review for inviting me to speak at the symposium today. My only regret is that I can't be there in person, but I mean, we can't help that. So I'm happy to be here virtually to talk about the connection between the 19th and the 15th Amendment. So I hope you'll find my comments both enlightening and somewhat provocative, or maybe very provocative, maybe not provocative at all. Well, we are here to, okay, I'm not ready for the slides yet. We are here to commemorate the 100th anniversary of the 19th Amendment's ratification. I use the term commemorate instead of celebrate because I think it's important to remember that this anniversary is also a time to reflect on the lost opportunities to advance equality for all 100 years ago. Such a reflection seems especially appropriate as we are days away from yet another presidential election. First slide, please. I want to start with a comment about terminology. We commonly speak of the 19th Amendment as conferring the right to vote on women, but that's not what the actual text says. And there are the words for you, but I'll repeat them. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Any right to vote, however, is conferred by the state, not by the federal Constitution. The 19th Amendment, like its cousin, the 15th, only prohibits states from disqualifying someone from becoming a voter due to sex or race in the case of the 15th Amendment. Next slide, please. What we casually call the right to vote is actually a franchise, a privilege that the state can choose to confer or withhold. The Founding Fathers constantly chose not to include voting as a constitutional right, instead giving the states the power to determine voter qualifications. The lack of this constitutional right to vote and the varying qualifications of states reinforce the established view of the time that the vote, however essential to a popular government, was not a natural right, but a privilege conferred by government and subject only to constitutional and statutory limitations. But I digress. Any discussion of the 19th Amendment must be contextualized by mentioning the 15th Amendment, which prohibits the states from denying the franchise to citizens based on their race. That amendment is 150 years old this year, but there's been no real celebration of that. For good reason. My focus today is on the expansion of the franchise to include women and African American women and men. In my talk, I will explain how the histories of the 15th and the 19th Amendments are inextricably intertwined and how both amendments faced resistance that continues today. Mississippi, for example, did not ratify the 19th Amendment until 1984. Yes, 1984. And Tennessee, in 1997, became the last state to ratify the 15th Amendment. I hope you find that shocking. At the beginning of the nation, access to the franchise was generally limited to property owning or tax-paying white males, who constituted about 6% of the population. But by the mid-1800s, universal male suffrage was becoming a reality. Thus, in one sense, expanding voting access in 1870 to include Black men and in 1920 to include women was consistent with the general broadening of the franchise. Nevertheless, as I shall explain, public sentiment and legal mechanisms impeded access to the franchise for each group. In each case, even a constitutional amendment, in some cases, even a constitutional amendment was insufficient protection. Black women and men, and many poor white women, had to wait until the 1965 Voting Rights Act before major impediments to voting were removed. And as anyone who reads newspaper today knows, voter suppression efforts continue today that disproportionately impact non-white voters, and I should add poor white voters as well. Most discussions of the women's suffrage movement start with the 1848 Seneca Falls Conference. But to provide context, I want to start a decade earlier by discussing the legal status of white women and free African Americans. Next slide, please. According to historian Martha Jones, there's no consensus among historians about the status of free Black people during the antebellum period, specifically whether they were considered citizens before the Dred Scott decision. Jones concludes that the only consensus that emerges is one about the importance of fixing their status. Although free Black activists considered themselves citizens, they did not agree about whether the state might affirm the fact. Perhaps more importantly, citizenship was important to protect free Black people from expulsion. Citizenship guaranteed that they would not face the possibility of deportation or statelessness. Not all antebellum Americans saw the relationship between rights and citizenship in the same way. For some, being a citizen was a gateway to rights. Citizenship, while a prerequisite in most states for voter eligibility, did not ensure voting rights. During that era, to be deprived of the vote did not mark one as a non-citizen. Unpropertied men, women, and children were citizens, even though in some jurisdictions they were ineligible to vote. On the other hand, exercising rights was evidence of citizenship. If a person exercised the right to vote, it was evidence that that person was a citizen. The process of making rights was linked for Black Americans to a broad claim about the privileges and immunities of citizenship. Those of you who had con law have heard those words. In addition, anti-Black racism led to legal disabilities, exclusion from militia service, naturalization, suffrage, public schooling, ownership of real property, office holding, and courtroom testimony. In the 1830s, free African Americans were unable to make the laws that regulated their communities. Thus, access to political rights, the vote, jury service, office holding, was key to winning lasting equality. Free Black activists in questioning their citizenship status saw their own interest in the anti-slavery cause. They reasoned that free Black people would be barred from full equality as long as slavery persisted. To oppose slavery, to fight for its downfall, was to protect one's freedom and work for liberty of family and friends. As a result, some Black activists joined the radical abolitionists to press for the immediate end of African slavery. Next slide, please. What about white women, you might ask? Well, white women saw their own oppression in the plight of enslaved African Americans. As persons who were legally disabled by the laws of marriage, property holding, and inheritance, white women saw slavery as analogous to their own condition. Women, they argued, were owned by men without rights or the capacity to act by way of individual will. Thus, they suffered under the slavery of sex. They actually used that term, slavery of sex. Many African American scholars considered white women's comparisons of their plight to the enslavement of African Americans as trivializing slavery. Feeling like you're enslaved is quite different on many levels from being enslaved. Many women, awakened by improved educational opportunities for women, were attracted by the political movements of the 1830s and the 1840s. They longed to participate in political life, but the social mores of the time frowned upon women speaking in public. Some became active in the abolitionist movement. The crusade taught a small band of women to speak in public, to organize a petition drive, and perhaps more important, to apply the language of natural rights to the question of human rights. White and Black women also pushed for leadership positions in anti-slavery societies. In 1840, when women secured leadership in the American Anti-Slavery Society, many men who had been active in the organization left. Black women supported this move, but while 4 white women were elevated to the society's highest ranks, the sole Black woman candidate was not. Racial bias might explain the loss. Nevertheless, it took courage to be an anti-slavery woman. Some risked their reputations, challenging those who thought the politics of abolitionism was men's business. Others risked the charge of overstepping by fueling the national strife over slavery's future. Those who left the confines of their home, churches, or women's circles encountered ridicule. The consequences for Black women was especially severe. Black women abolitionists endure a litany of risk and racial violence that marred their public lives, even as teachers and church-going women. One example occurred in May of 1838 at an interracial meeting in Philadelphia to organize a national women's anti-slavery association. On the second day of the meeting, at an evening session where well-known abolitionists were scheduled to speak to a crowd of 3,000, attendees were met by a white mob outside Pennsylvania Hall, who assaulted several African Americans as they left the meeting. The mob was especially provoked by the presence of Black women. When those in charge of the meeting refused to exclude Black women, the mob set the hall on fire. Hostility also faced advocates of women's suffrage. The famous 1848 Seneca Falls Women's Rights Conference was lambasted as the Hen Convention. The participants were described by one newspaper writer as divorced wives, childless women, and some old maids. Except for African-American abolitionist Frederick Douglass, the convention was all white. Douglass's presence at the convention was fitting. Despite sexism within the abolition movement, Douglass openly supported women's suffrage. In fact, the same year, Douglass, then president of the National Convention of Colored Citizens, added the issue of women's rights to the convention's agenda, though it was not an easy fit. At that convention, Elizabeth Cady Stanton joined with Frederick Douglass in making the case that the right to participate in government is a fundamental principle of equality, for which all other rights would flow. Douglass and Stanton prevailed, but by a small majority. This was a pragmatic coalition. The linkage between women's suffrage and abolition seemed more compatible to some women's suffragists than others. African American women, because of their gender and race, appreciated the close connection between both causes. They joined white suffragists like Anthony and Lucretia Mott in pushing for universal suffrage. Black women suffragists, like their white counterparts, tended to come from middle class as opposed to working class backgrounds. Most were freeborn, educated women from the North, with one exception, notable exception, Sojourner Truth, who was a formerly enslaved abolitionist and an outstanding lecturer. Unfortunately, the role of Black suffragists, as has been referred to before, in the quest for the 19th Amendment has been largely erased from the movement's history, purposely by the women, starting with Elizabeth Cady Stanton, who wrote the history of the movement for women's rights to vote. So too was the role that race played in the quest for women's suffrage. In many respects, this pragmatic coalition between suffragists and abolitionists reflected similar goals. Members of both movements wanted equality, and each thought that political rights, a seat at the table, were key to winning lasting equality. A few scholars, however, see the alliance between radical abolitionists and women suffragists as more than merely one of political convenience, arguing that the alliance embodied a shared conceptual vision as well. This vision fused the principles of the American Revolution concerning representation with radical egalitarianism of the abolitionist movement. There's probably some truth in both views. The Civil War interrupted and ended the first generation women's suffrage movement. After the war, the controversy over the citizenship status of African Americans, free or enslaved, created by Dred Scott, provided an opportunity to reconsider this country's social contract. With the ratification of the 13th Amendment, formally emancipating all formerly enslaved, people of African ancestry, the question of their citizenship remained to be determined. African American and many white women saw the suffrage issue differently. For African American women, suffrage was seen as a collective, not an individual possession. They preferred universal suffrage, but when faced with the issue of Black male as opposed to women's suffrage, they selected what they deemed was best for the whole African American community. Universal suffrage was important to the women's suffrage movement, But when it became clear that the nation was not prepared to adopt women's suffrage, white suffragists divided over whether to support Black male suffrage embedded in both the 14th and the 15th Amendment. This rupture between the suffragettes and former abolitionists was caused in part by debates over the 14th and the 15th Amendment. Next slide, please. The proposed 14th Amendment provided an opportunity for African Americans and white women suffragists to push for a constitutional right to vote, or at the very least for universal suffrage. The first clause of the amendment defining birthright citizenship does not mention gender, but the second clause of the amendment only applies to male inhabitants whose right to vote is denied. At least one version of the proposed amendment included a provision for universal suffrage. When that proposal failed, prominent suffragists like Stanton and Anthony of the American Equal Rights Association opposed Black male suffrage unlinked from women's suffrage. Anthony proclaimed, "I will cut off this right arm of mine before I ever work for or demand the ballot for the Negro and not the woman." Stanton expressed similar sentiments, saying she did not believe in allowing ignorant Negroes and foreigners to make laws for her to obey. After the ratification of the 14th Amendment without any reference to women's suffrage, Black and white women continued to push unsuccessfully for the expansion of the 14th Amendment to include universal suffrage. They made arguments before Congress, and then in 1875, the Supreme Court in Minor versus Happersett ruled that the 14th Amendment does not grant women the right to vote, sort of ending that leg of the struggle. But the final straw for many white suffragists occurred when the 15th Amendment only enfranchised Black men. But there were some white suffragists who joined with Black women, adopting a more pragmatic view, reasoning that the nation would only accept one reform at a time. And if franchise rights were conferred on Black men, then other second-class citizens like Black and white women could become full citizens too. Those suffragists remained committed to universal suffrage. White suffragist Mary Oney Brown, for example, even outlined a legal argument for the enfranchisement of Black women under the 15th Amendment, since the language did not explicitly exclude women. She was not successful, but this was just one of many attempts by some white suffragists to repair the fractured coalition that existed after the Civil War. Those suffragists unwilling to postpone women's suffrage broke with the American Equal Rights Association, resulting in its demise. In 1869, the women's suffragist movement split into two camps. The National Women's Suffrage Association, headed by Stanton and Anthony, which strongly opposed the exclusion of women in the two Reconstruction amendments, and the American Women's Suffrage Association, headed by Lucy Stone, who supported the 15th Amendment. Unsurprisingly, most Black suffragists sided with the Stones group. As we know, the 15th Amendment did not result in widespread Black male enfranchisement. After a brief period following ratification came an era of disenfranchisement by legalism and terror. During this period, however, Black suffragists pushed for both women's suffrage and the reenfranchisement of Black men in the South. In 1890, the two branches of the women's suffragist movement merged into the National American Women's Suffrage Association. The organization's goal was a constitutional amendment extending the franchise to women. White Northern and Southern suffragists supported what they call educated suffrage, which would restrict the vote to women who could read and write English, a distinct minority in the country at that time. As one scholar writes, the women's rights movement throughout its history defined its priorities with reference to white, middle, or upper-class women. Thus, discrimination that affected all women included the right of owning property, but not Black women's voting rights. Women's organizations in this period, the early 20th century, like their 19th century predecessors, remained largely segregated. And in point of fact, the southern branches of the suffragist organizations excluded Black women from membership. By early 20th century, some leaders within the women's suffrage movement even openly espoused granting white women the vote to offset the Black male vote. Nevertheless, from the 1890s to ratification, Black men and Black women and Black men remained in the women's suffragist movement, fighting both racism and sexism simultaneously. Black suffragists pragmatically continued to push for the women's vote, believing that if Black women could secure the vote, mainly in northern states, they might be able to restore the vote to Blacks in the South. Nevertheless, the historical relationship between African Americans and white women suffragists created bitter sentiments among many Blacks that have not yet subsided. Next slide, please. The racist and xenophobic sentiment of many of the NAWSA was exemplified by a 1903 resolution passed by the organization, noting that, and I'm quoting here, the enfranchisement, there are more white native-born women who could read and write than all Black and foreign-born voters combined, so that the enfranchisement of such women would settle the vexed question of rule by literacy, whether homegrown or foreign. Thus, the main goal of this united suffragist movement was obtaining the vote for white women. Members of Congress expressed similar sentiments. By the beginning of the 20th century, public sentiment for women's suffrage was growing. A few states, primarily in the West, already allowed women unrestricted access to the vote. Yet continued resistance to the Black vote threatened efforts to secure the 19th Amendment. Notable were the efforts of two senators from Mississippi. One was the newly elected Senator James K. Vardaman, who won office on a campaign promise to repeal the 15th Amendment. As an opponent of the 14th and the 15th Amendment, Senator Vardaman advocated wiping away federal provisions for equal protection, due process, and voting rights to stop the Black Peril. When direct measures did not pass, Vardaman tried to use the women's suffrage movement to accomplish his purpose, proposing a compromise, the repeal of Black voting rights in exchange for women's suffrage. Vardaman's efforts failed, but 19 senators voted for his proposal and 48 against. So did the efforts of John Sharp Williams, Mississippi's other senator, who proposed to insert the word white before woman in the 19th Amendment. The Senate rejected this proposal by a vote of 44 to 21. Still, 21 senators did vote for it. In the end, the 19th Amendment was passed by Congress and ratified by the requisite number of states. In 1929, the Supreme Court ruled in Lesser versus Garnett that the amendment had been constitutionally established. Next slide, please. Historian Martha Jones writes that in the late 19th and early 20th century, one might argue there were two separate women's suffragist movements, with Black women organizing separately out of necessity in light of segregation and out of a sense that their goals were different, though overlapping with the goals of white women. Next slide, please. Months before ratification of the 19th Amendment, the NAWSA dissolved, becoming the League of Women Voters, which focused on women's education. Once again, the women's suffrage movement split, with some satisfied that their goal had been accomplished. Others continued the struggle, campaigning against obstacles like the poll tax, used to disenfranchise Black men and women, as well as poor white women and men in the South. The ratification of the 19th Amendment did not result in dramatic increase in women voters. Fewer women than men voted in elections. A study in the early 1940s of the 8 Southern states attributed part of the problem to the poll tax, where in states like Alabama, 2 men were registered for every 1 woman. The study suggests that the difference in voting rates had more to do with sexist laws and women's perilous economic position than their lack of interest in politics. Many white women in the South, for example, found the poll tax an obstacle to exercise the franchise. Registrars refused to accept payment from white women, and others eliminated ballots cast by women under the pretext that they had not paid their tax. The lingering effects of coverture also made payment of the tax more difficult for women. In many states, married women were not entitled to their wages, the wages of their spouse, or their children. Men remained the almost exclusive owners of property. There was no consensus among the coalition of women, Black and white, who attacked the poll tax about its long-term goals. Some women only wanted to repeal the tax, while others saw the repeal effort as one aspect of the larger movement to improve conditions for women, or even broader, advocacy for women's civil rights. Initially, as usual, middle and upper class women comprised the bulk of the movement. Black women worked mainly through the Colored Women's Club movement with the white-led National Committee to abolish the poll tax. But they worked largely in separate circles because, like in past movements, integrated groups of women supporting social progress were often harassed. I mean, you were more likely to be harassed in an integrated group than in a racially segregated group. Throughout the 20th century and into the 21st century, voter suppression and disenfranchisement efforts continue to target Black voters, women, and men. State and federal courts, including the United States Supreme Court, participate in this effort. In the summer of 1964, the Democratic National Convention, Fannie Lou Hamer, a civil rights advocate from Mississippi and part of the Mississippi Freedom Democratic Party, challenged the seating of the regular delegation from the state, who had been selected without any input from Black Mississippians. Her testimony before the Credentials Committee was televised live on national TV. A working class, rural Black woman who I knew testified about the economic hardship she experienced when she tried to register to vote. She lost her job, and about the physical and sexual violence she suffered for attempting to register other Black voters. President Johnson, viewing the procedures, abruptly called a press conference to draw attention away from her powerful testimony. But Mrs. Hamer's full testimony was considered so newsworthy that it was rebroadcast later for the world to see. The 1965 Voting Rights Act was signed into law 14 months later. Next slide, please. Mrs. Hamer ended her testimony before the DNC Credentials Committee with these words. Please play the clip. As I feared, her voice cannot be heard, but I have put what she said there on the screen. Her words were, "If the Freedom Democratic Party is not seated now, I question America. Is this America, the land of the free and the home of the brave, where we have to sleep with our telephones off the hook because our lives be threatened daily because we want to live as decent human beings in America?" Please go and look at this clip on YouTube. I mean, it is quite powerful. Next slide, please. So, should we celebrate instead of commemorating the 100th anniversary of the 19th Amendment? The amendment is not considered important to many Americans. Historian Martha Jones said, Mrs. Hamer never spoke of the 19th Amendment the way she did of the 14th and the 15th Amendment. Yes, she was a woman, but she did not see the terms of the 19th Amendment, the one that constitutionalized women's voting rights, as protecting her. As she said in a 1971 speech, "Nobody is free until everybody is free." I present her words as my challenge to you. Work to make them a reality. Nobody's free until everybody's free. Thank you.
Thank you, Professor Banks. What a perfect way to commemorate this occasion. I'm going to stop sharing. So I am going to ask you a few questions from the chat box now, if that's all right.
Yep.
Great. So the first question is, how do you see the goals of Black and white women aligning today in 2020?
Well, we tend to talk about women in both races as being monolithic, and we also are talking only in binary terms. And so, I mean, I think some of the comments that were made in the first panel are interesting. You know, I think that because most Black women, I mean, because most women today work, and women who are working class must work, childcare, provision for childcare, and some system for childcare, pregnancy, real pregnancy leave. I mean, in European countries, women are paid to be off for a year. And so they can afford to stay home and be with their children. And I think those are that especially the first year or two of a child's life are really essential in preparing that child to learn and become a better citizen. And I think that's a goal. And I've argued in another article that one of the failures I see of this sort of middle class women's movement generally is the failure to negotiate the work that women have historically done in the home and still continue to do disproportionately, renegotiate that arrangement. And so we tend to have two jobs. And even though men increasingly are taking on more of that second job, we tend to disproportionately turn that job over to other women, generally poorer women, generally non-citizen women. And I argue that in a way that's somewhat exploitive because they are not paid well to do a very important and a very hard job. That's just one example.
Thank you. What role do you see men playing going forward in the women's movement, given their lack of participation in the past, or given their role in the past?
Well, yeah, I think that sexism is so deeply ingrained in society, not just American society, but in society globally. If you travel around the world, you will see that women in I mean, every country I've been in are not full citizens to some degree or another. And I think that this is the norm. And women have been trying, certainly in this and other countries, have been trying to disrupt this norm. But you know, it's still very strong. I mean, and in this country, our failure to get more women in high elected office. I mean, I would argue that for non-white women, access to the vote remains a problem. But for white women, it's access to high political office, and that is a byproduct of sexism, and it's mainly implicit. It's unconscious. It's normalized, and we talk about people becoming woke. Well, I mean, it's not just becoming woke to race; it's becoming woke to gender, and I think that that's a really hard and long-term project.
I agree. The next question goes back in time to the suffragettes. What do you think about the notion that the suffragettes' tentative advocacy as abolitionists and for the voting rights of Black women just reflected that they were a product of their time?
Well, I mean, there are a couple of things. One of the things that happens, I mean, one, you could be for abolishing slavery, but you would not necessarily be for treating Black people as equal to white people. And I think that some abolitionists were like that. I mean, we saw that with desegregation in this country, that some people were in favor of removal of the Jim Crow signs and the Jim Crow laws, but they did not consider Black people equal to white people. And then you had other people who were true believers. And I think those were the women and the men, there were few, but there were men who worked for universal suffrage because they were the egalitarians. I mean, that's the philosophy of the radical, and I have to say the radical abolitionists, because most of the abolitionists were just for gradual emancipation. They weren't for immediate emancipation. And so, and then I would also argue that after the organization split in 1869, you had the infusion of a large number of suffragists from the South who brought with them this ideology of white supremacy, which was becoming the norm in the country generally, and certainly with the election of people like Woodrow Wilson, helped. And so that infused existing biases, and I think there's residual anger about missing the opportunity in the 14th and 15th Amendment, and hostility at Black men, even though they had been disenfranchised. And so, the race stuff, I mean, I'm not sure that women would have gotten the vote in 1920 had the racial aspect not been used to nudge it along. Because, I mean, what was sort of amazing, if you look at the commentaries, the Southerners, many of them were saying, we need white women to vote to offset Black vote in the South. I'm going, they've all been disenfranchised. And Black people were not fools. They realized that the Black women in the South would be disenfranchised as well. But being pragmatic, when you're a minority, you work with what you have, and you figured that you could use the votes in the North. And, we had people moving finally from the South to the North. And so, that was, it is.
And bringing it back to current day, well, the first question starts off thanking you for your great talk. And then they ask, in 2016, 64% of eligible Black women said they voted compared to 54% of eligible Black men. What do you attribute the disparity to?
Well, I was just talking to my class about this the other day. Why isn't Election Day a national holiday? The people who have to work on Election Day are generally people who are poorer. Professor Harvard has already told us that Black women are pretty much on the bottom step here of the economic ladder. Many of them can't afford to take the time off to vote. And some may feel, given the limited opportunities, that they don't have much of a choice. Now, I'm of a different mind. When I lived in Mississippi, I can't think of a single candidate I voted for that I thought was really a good person, but it was like the hold your nose and vote. You voted for the least offensive person. And, and that's what some people are probably going to do for this election. But I mean, so I think it's a combination of things. I mean, part of it is what was the date you gave me again?
In 2016, 64% of Black women and 54% of Black men.
Oh, yeah. So I think some of the, I mean, actually, I'm a little surprised because with felony disenfranchisement, although increasing number of women are now in prison as well, and have, especially because of drug-related stuff, and some of them may have lost their right to vote, lost the franchise because of felony disenfranchisement laws. So, I mean, bottom line, I'm speculating, I don't know.
Absolutely. So going forward, most everyone here is law students or law professors who are listening to you right now. Do you have any advice on the people learning about both these amendments and the laws enacted under these amendments for our work in the legal profession going forward, and certain things to keep in mind.
Well, I think the things that can be learned. I mean, I'm constantly amazed at the ingenuity of the women who push for the vote. Like the woman, the suffragist who said, "Well, yeah, the 15th Amendment doesn't contain any gender restriction, so it's possible that maybe we can argue that Black women have the right." Can you imagine if Black women had been given the right to vote in the 19th century before white women, what would have happened? But I do think that we need to be creative in thinking about solutions. And we also have to realize that the vote is a powerful weapon. If it wasn't so powerful, then people wouldn't spend so much time trying to prevent people from exercising it. And you need to look at the people whose vote is being interfered with. Because that's the power source that they fear the most. And you need to be on the side of those folks.
Thank you. I'm just going to double check. I think those are our questions for now. Do you have any last remarks you'd like to make before we move on to panel 2?
Well, this has been fun. So thank you again.
Thank you. And I know it's hard because you can't see everyone, but there are so many people cheering you on, and we are very grateful that you took the time to share your knowledge with us. So thank you, Professor Banks.
Thank you. The struggle continues.
Yes, the struggle continues. Okay. All right, everyone. Thank you for staying with us through Professor Banks' talk. I am so excited to transition us into our last panel. The day is flying by. So I'm going to pull up our second panel and give me a moment while I do that. Okay. Professors Thompson, Demleitner, and Ligon, you can now turn on your cameras when you're ready. Hi, everyone. Okay, our final panel of the day, and it is my pleasure to introduce Professor Duryea. She is a legal historian who researches human rights, comparative constitutional development, and administrative law. Prior to coming to St. John's, she was the Charles W. McCurdy Fellow in Legal History at UVA Law, and a Fulbright Hays Scholar in Morocco and Kuwait. Now, Professor Duryea teaches administrative law and legal history at St. John's. Professor Duryea, take it away.
Thank you, Sam, and good afternoon, everyone. I'm so delighted to be here. I want to echo everyone's thanks to Sam, who's done a really marvelous job of organizing this event. And I'd also like to thank our first 3 panelists and, of course, Professor Banks for their really engaging and thought-provoking presentations so far. And I am thrilled to introduce the 3 members of our second panel, who are all presenting papers that engage questions around sexual abuse, exploitation, and sex work. So I think we're going to have a really interesting conversation. So first, we will hear from Professor Nora Demleitner, who is the Roy L. Steinheimer Jr. Professor of Law at Washington and Lee. And she will be presenting her paper entitled Sex Work or Prostitution, Time to Reassess Repressive and Punitive Policies Against Women. And then we will hear from Professor Micah Thompson, who is the Associate Professor of Law at the University of Missouri, Kansas City School of Law, whose paper is entitled Sexual Exploitation and the Adultified Black Girl. And finally, we will turn to Professor Nicole Ligon, a supervising attorney and lecturing fellow at Duke Law School, who will present on protecting women's voices, preventing retaliatory defamation claims in the Me Too context. So, and with that, I will turn it over to Professor Demleitner.
She's having some trouble with her camera really quick, so I'm going to see if I can turn it on for her.
Okay, and if that doesn't work, we will probably go to Professor Thompson. So Professor Thompson, just a warning that you might be first. Sam, should we go ahead and flip up the order?
Yes, I think so. Well, I'll figure this out. Professor Thompson, I'm going to make you the presenter now. Oops.
Okay, so I think I can share my slides, so I'll go ahead and get started if that works for everybody. I've got my own timer so that I will not go over, so you'll hear a beep. I'm sure I'll be in the middle of a sentence. So, okay, I will go ahead and share my screen. Okay, hopefully you all can see my slides. Yes? All right, so my talk today is on sexual exploitation and the adultified Black girl. I really want to thank the St. John's Law Review for inviting me to speak. Sam, you've been so amazing on top of everything. It's been wonderful to work with you. And I was really excited about my bag of swag. I tweeted about it, including the cookies that my sons ate before I had a chance to eat any, so, you know. It happens. But anyway, I'm excited to be here to talk to you about adultified Black girls. All right, so first slide. So this is Blue Ivy Carter. So this is the daughter of Beyonce and Jay-Z. She's, you know, famous just because of who her parents are. And earlier this year, she turned 8. She got lots of happy birthday wishes. These were 2 pictures that were posted, one by her grandfather, the other by Megan Thee Stallion, the rapper. And so in response to these photos, there was some reaction, including this tweet from E! News, where someone tweeted, "Can someone please explain to us when Blue Ivy became an adult? Happy 8th birthday to the baby Queen Bee." So there was some negative reaction to this tweet about Blue Ivy being an adult. Black Twitter in particular had something to say about it. So these are just 2 of the many responses that were posted on Twitter. One of them saying, you know, this is really just an 8-year-old. She's got a pressing curl. Stop treating Black girls like they're adults. The other person says that there is some danger in society viewing Black girls as if they are women. So I wondered, you know, after seeing this, and this is kind of an area that I've been thinking about for a while, is it true that society views Black girls as being older than they really are? Well, the research tells us that this is true. So in 2017, the Georgetown Law Center on Poverty and Inequality put out a study called Girlhood Interrupted, and they surveyed over 300 adults of various races and ethnicities and asked about their perceptions of Black girls compared to white girls of the same age. And these were their findings, that the study participants tend to see Black girls as needing less nurturing, less protection, that they don't need as much support, don't need to be comforted. They are more independent, more knowledgeable about adult topics, including sex. The researchers concluded that there is this thing called adultification bias, and it is the tendency of society to view Black girls as less innocent and more adult-like than their white peers. And the researchers found that there is a lot of there are some really negative implications for this adultification bias that impact various areas. So we could be talking about the juvenile justice system. We could be talking about school disciplinary processes. My research focus is on sexual exploitation. So the researchers found that there is a blurring of the line between childhood and womanhood for Black girls, that it begins as early as 5 and is most prevalent between the ages of 5 and 14. We continue to see it even after the age of 14. So, like I said, my focus is on sexual exploitation. And so when I go back and look at these findings from the Girlhood Interrupted study, I see that, the tendency to see Black girls as needing less protection, the tendency to see them as more knowledgeable about adult topics, including sex, potentially having a very negative impact on how the law protects Black girls when it comes to sexual exploitation. And it made me think about statutory rape specifically. So you all, I'm sure, have an understanding of what statutory rape is. Traditionally, it was a strict liability crime. So if an adult has sex with a minor, then that is a violation of the statutory rape laws. There is no mens rea or guilty mind requirement. Traditionally, there was not, at least. But things are a bit different now, and so I'm going to talk about that. But first, I want to consider the purposes of our statutory rape laws. Why do we have these laws in place that prohibit sexual contact with minors? Michelle Oberman has written many articles on statutory rape laws, the purposes, the policies supporting statutory rape laws, and she's come up with 2 reasons that she believes statutory rape laws exist. One is to protect teenagers from themselves, that they may be too vulnerable, they may be in a position of vulnerability that prevents them from being able to give good consent to sexual activity. Also, it would protect them from those who would prey upon that specific type of vulnerability. She also argues that statutory rape is a really good complement to traditional rape law, which defines consent in such a way that an individual's fear or decision to consent, maybe because of coercion or something like that, is not necessarily recognized as a good defense, if you will. So she says that statutory rape laws need to be in place to provide that complement to what we understand as traditional rape jurisprudence, which would look at consent, even if given because of coercion, even if given because of fear, as effective consent to sexual activity. All right, so there is this defense called mistake of age defense that's really kind of the central part of my paper. And while statutory rape laws are generally strict liability offenses, in more than 20 states at this point, there is a mistake of age defense that's available to individuals who are charged with a statutory rape offense. This is an example of one in Illinois. So in Illinois, the age of consent is 17, and the mistake of age defense is available for certain statutory rape offenses. It is an affirmative defense, and it is allowed first where there is alleged sexual contact between an offender who is under the age of 17, so a minor offender, and a victim who is at least 9 years of age but under 17 years of age. Next, sexual contact between a victim who is at least 13 years of age and an offender who is at least 5 years older than the victim. So traditionally, this is kind of known as a Romeo and Juliet type of defense, where you have an offender who may actually be a young adult, but who is not that much older than the victim. I wouldn't call it a Romeo and Juliet defense. That's a heteronormative kind of term. I call it star-crossed lovers defense. So you'll see that show up in my later slides. The last category, the most troubling one, I'd say, is that the affirmative defense is available for sexual contact between a victim who is at least 13 years of age but under 17 and an offender who is at least 5 years older than the victim. So that is a much broader application of the mistake of age defense, I would say. Montana has a mistake of age defense as well. It is broader in terms of its application to statutory rape crimes. So in the sex crimes section of the Montana Criminal Code, it states that this mistake of age defense can apply to any sex crimes charge. However, it's not available when the victim is under the age of 14. What is really telling about the Montana law, and the reason that I selected it from the various statutes that are out there, is that there is a comment to the statute that is very telling and concerning, and I'll just read it. So the comment states that this section rejects concepts of virtue, chastity, or good repute as possible defenses. So promiscuity, if you will, is not a defense to statutory rape, but it does envision cases of precocious 14-year-old girls and even very young prostitutes who might be the victimizers rather than the victims. So when I think about, the potential adultification of kids, particularly at around the age of 14, which we know is supported by the Girlhood Interrupted study, what Montana law tells us at least is that those girls might be the victimizers and not the victims. And so the state allows for this mistake of age defense to apply in that kind of scenario. So let's look at how this defense actually works. People versus Gonzalez is a case that I selected from Illinois that applied the mistake of age defense. It is a case where the defendant was charged with having a sexual relationship and impregnating a 14-year-old when he was 23 years old. The defendant, of course, asserted mistake of age. The pattern instruction in Illinois, the instruction that goes to the jury, defines reasonable belief in a way that doesn't actually give the jury much, in my opinion, but it did inform the jury, that reasonable mistake was an option. That instruction was not given in the trial court, and so the appellate court says that was an error. The court also found that once the defense is asserted, that it is the state's duty to disprove the mistake of age defense. The court noted there that the instruction was necessary based on the facts. First, because the victim gave some conflicting testimony about whether she had informed the defendant of her age. And then there's this part that I've highlighted. The court and the jury were also able to observe the victim's appearance and demeanor on the witness stand. So to me, this suggests the idea that in determining if the mistake of age defense should work, it is the jury's job to judge the apparent age of the victim based on appearance and demeanor. Again, troubling in light of this idea of adultification. So in looking at the cases that have dealt with the mistake of age defense, what we see is that there are various methods of proof. The defendant's testimony is one. I thought that the victim was older than the age of consent, right? The victim's testimony and demeanor, as mentioned in the Gonzalez case, is a way to establish it. Witness testimony, witnesses who come in and testify that at the time of the incident, which could have been a year or more, before the trial, that the victim either appeared to be older or appeared to be their actual age. Photographs taken at the time of the incident are used as evidence. And then finally, something like social media is actually used, sometimes to prove, sometimes to disprove the reasonable mistake of age defense. So I'm left with some questions about, what the protection looks like for adultified Black girls when we consider the use of this mistake of age defense. And while there are, a number of jurisdictions that recognize the defense, I also wonder about, whether attitudes about the adultification of Black girls even impact charges where the mistake of age defense isn't present. That's something that I'm kind of still thinking about. But this piece is very much focused on the mistake of age defense. I'm also curious about, whether the methods for proving or disproving mistake of age place the government at a disadvantage when the victim is an adultified Black girl. And are there any changes that could solve this problem? One potential solution is to get rid of the mistake of age defense. So this is a quote from a 1916 Missouri Supreme Court case. This is a concurring justice's statement that, it's well known that some girls appear to be older than they actually are, and that a man who decides to have sexual intercourse with a girl without verifying her age takes a risk. If it turns out that the girl is underage, then it is his fault. So one option would be to just get rid of the defense completely. But I find some problems with that approach. One is that I think that, if mistake of age is no longer a defense, then we will likely see more convictions of minor defendants. And so these would be convictions of defendants who are below the age of consent. because a statutory rape technically happens, say, when two 16-year-olds have sex with each other in the state of Illinois, and whoever is charged first is the defendant in that case. I think there's a strong argument that minors may be less equipped to properly judge age. And so if we take away the mistake of age defense, then we may see more convictions of minor defendants. I think we'd also see more convictions of young adults. And so by young adults, I mean individuals who have just reached the age of consent. So a 17-year-old in Illinois, for example, if the star-crossed lovers or Romeo and Juliet or Romeo and Romeo defense is not a complete bar and there is no mistake of age defense available either, then we could see more convictions of young adults. Even where there is a relationship, boyfriend and girlfriend. One of the participants is 18 and the other one is 16. Finally, I think there'd be more effective weaponization of the statutory rape laws. So Professor Garfield Tenzer, in a 2019 article, looked at crime statistics, and she was able to determine that most of the folks who actually report statutory rape violations are the parents, usually the white parents of teenage girls. And she says that the reports happen because parents are upset by the relationship. They believe that their daughters have engaged in activity that is immoral. And in some instances, they are upset by who the boyfriend is. So there could be some racial implications there as well. And so without a mistake of age defense, I think that there is the potential for greater weaponization of the statutory rape laws. My potential solutions, just real quick, I think I've got just a few seconds left here and my alarm is going to go off. More limited use of the mistake of age defense. So limiting its use to minor defendants, but never when the victim is under the age of 13. Limiting the use to young adult defendants, but never when the victim is more than 4 years younger than the young adult defendant. The other proposal that I'm looking at is the idea of changing courtroom protocols to ensure that jurors understand the existence of adultification bias, how it might play out, and that they receive better instruction on objective measures for judging a parent age. So that is all my time. Thank you so much, and I look forward to your questions.
Thank you, Professor Thompson, for that really thought-provoking presentation. I'm looking forward to discussing it after we hear from our other two panelists as well. And I see Professor Demleitner, I see you now. It's very nice to see you. I'm glad your camera is up. Are you feeling ready to present, or shall we go to Professor Ligon first? You're muted. I think we're going to go ahead and go with Professor Ligon. I'm sorry, everyone, for my fluctuating voice here. So let's go to Professor Ligon first, and then we will return to Professor Demleitner for our final presentation of the day. So I will hand it over to you.
Okay, Professor Ligon, I just made you the presenter, so let me know if you have to still share your slides.
Great, thank you. So this has been such a great conference so far. Thank you so much, Sam, for organizing this. Thank you to Professor Thompson for that great presentation. And one thing I just want to point out is we have such a strong grouping of women whose voices are being heard, and this is a wonderful platform for women's voices to be heard. And so my piece deals primarily with how do we ensure that voices within the sexual assault, sexual harassment context get heard when there are especially important voices in terms of women's voices. And so the Me Too movement really upended public conversation about sexual assault and sexual harassment. And in so doing, it really elevated social consciousness surrounding the personal and professional life and professional obstacles that women regularly are facing in their daily lives. So as the movement ended up gaining some momentum, and it really did, it really took off it started in 2006, but we learned a lot when social media popularized the hashtag, and it really took off in 2017. And during that time, it began to really amplify the voices of a lot of brave women who had been historically silenced by dominant culture and concerned about coming out with regard to their stories, their experiences with sexual assault and sexual harassment. And so now, with all of these stories being told, we saw a little bit of a new problem where we had powerful men in various fields of industry who found themselves placed on the defense for the first time in their lives, and they did not like it. And in responding to these accusations that women were bringing, a lot of men who were well-resourced sought to silence their accusers by mounting these really expensive defamation lawsuits against their accusers. And so these retaliatory lawsuits against women who were speaking up about sexual violence served to silence many survivors from coming forward about their experiences at a time when sexual assault continues to remain vastly underreported. And so in my profession, in my job, one thing that I do is I work frequently with individuals, and it's primarily women, who want to come out, speak about their experience with sexual assault, sexual harassment, sexual violence. But when they approach me and they say, these are the stories that I want to tell, this is the narrative that I want to be heard, and I want my story to be heard because I think it's important, and these are really important stories that I'm helping these women to put together. One thing that always comes up, and one thing they're always concerned about is, well, what happens if I get sued? And that's a really reasonable concern. And it's not because these women are sitting there saying, I'm going to say something defamatory, right? They know their truth and they're saying their truth. But the problem is that the law of defamation especially isn't really suited to protect people's First Amendment rights. It's not there to ensure that these stories get told. Instead, we live in a society where the way in which the law works in this particular context is it's there to give plaintiffs their day in court, so to speak. And day in court is really just a euphemism, because day in court is not just a day. It is months, it is oftentimes years. And so you end up in these really lengthy defamation suits that cost, I think a recent study said that newspapers who are sued for defamation typically pay about $500,000 just to defend themselves in these actions. And that's not saying that those newspapers are liable for defamation. It just means the cost of defending oneself in an action like this is so incredibly expensive, exorbitantly so. The cost of legal fees, we'll talk about why that is in a minute, but they grow so exponentially high that it makes people really worried. What if I get sued by somebody who's much more well-resourced than I am? And again, it's legitimate. These are legitimate concerns. So what I do when I work with women is, in this context, is I'll try to allay some of their concerns. And I say, we're going to sit down and we're going to go line by line through your narrative. And we're going to try to flag areas where defamation concerns could arise. And that sounds really terrible sometimes when I think about it, because my goal is never to try to silence women's voices. It's to amplify them, but it's to amplify them in a safe way. And so I just want to give just a general rule of defamation so we understand where we're working from. And as a general rule, defamation requires a plaintiff to show that the defendant made an unprivileged and false statement concerning the plaintiff to a third party with the requisite level of intent, and that the statement caused the plaintiff to suffer some harm. And that's just throwing a lot at you right now. So we're going to break it down and try to understand why it is that these defamation suits, what we can do to protect women from experiencing them, but why it is that the law is so difficult for the defendants, and why do they have to pay so much just to defend themselves, just to tell their stories. And so bringing it down, there are some aspects with regard to defamation law that are kind of givens, right? So whether or not something was published or spoken to a third party, we assume that if there's a written statement, that publication element, that a third party has heard the statement, that's already met. Whether or not communication or a statement was unprivileged, frequently that's already met too, because unless the plaintiff said to the defendant, go ahead and publish the story, then that unprivileged component is going to be met. But a lot of these different elements within the defamation context require some serious factual analysis. So take, for example, the requirement that a defamatory statement be false. As a matter of settled law, an opinion can't be false, so that can't support a defamation action. But if a party in a defamation suit, parties in defamation suits frequently actually litigate whether or not the commentary that's at issue constitute opinions or facts. So, for example, if a survivor accuses their alleged harasser of being a sexual predator, questions might arise as to whether or not this terminology is a factual accusation, or is it the speaker's opinion. On the one hand, a plaintiff might point to something like a dictionary definition, and Merriam-Webster defines a sexual predator as someone who has committed a sexually violent offense and is especially one who's likely to commit more violent offenses. So if you were involved in an incident where you were being sexually harassed, perhaps not in a violent way, you might have a plaintiff who says, well, she called me a sexual predator, and that's a defamatory per se statement because she's accusing me of committing violent crimes, and I never committed a violent crime. And some courts might say, yeah, good point, plaintiff, and we're going to let the lawsuit continue. Conversely, you have another potential argument you can make as the defendant. You could say something like, no, look at how courts have ruled on this in the past. Whether or not someone is acting predatorily is a matter of opinion. And there's a lot of cases that will say that as well. So you end up in these lengthy disputes when you're in these defamation fights over whether or not something is a false statement of fact. Other things that you could end up in disputes about include the intent element, what was the intent of the speaker when she actually came out and spoke about her story. So you end up in these really intensive factual disputes when you're in these cases. And what it ends up doing is making it so cases can go on for years. And it seems silly, right? It seems like, well, why don't we just start from the point where we believe the person coming forward? And the law is just not set up like that. We don't have a system where we say, okay, well, we believe the person coming forward, and therefore, the plaintiff has to prove falsity. And if they can't do it in the very beginning, well, the lawsuit gets thrown out. Instead, in these cases that are arguably considered he said, she said cases, you end up in an instance where you have a plaintiff bring a lawsuit, and you have a motion to dismiss that gets filed by the defendant. And it's impossible for the defendant to win on a motion to dismiss. A motion to dismiss is that first stage. You could either answer a complaint or file a motion to dismiss. But when you file a motion to dismiss, you're basically saying, look, based on the complaint, there's no way in which this person is going to be able to prove the elements of defamation. And because we end up in all of these different factual disputes, what's an opinion, what's a fact, what was the speaker's real intent, it's almost impossible to get these suits thrown out in the motion to dismiss context. So what does that mean? What happens next? It means that the victim or survivor, I don't like to use that term victim, it means that the survivor is forced to endure a really lengthy discovery process. And discovery is such a strange term because the concept is that you're going to discover more facts and you're going to be able to, on the basis of those facts, decide, what was the defendant's intent and what was she thinking? Was it an opinion? Was it a fact? But sometimes, and frequently in the case of sexual assault and sexual harassment, it's really hard to get the factual evidence that you need to be able to prove that something happened. Because you don't always have contemporaneous witnesses. You don't always have the evidence. You don't have a videotape of an encounter. The question sometimes falls on who are we going to believe? Whose story seems most credible? And if you're going to take it all the way to the trial level, then you end up with that falling on juries, and the juror selection process is not always a fair process. But in the discovery process, it means that you're taking this defendant, the survivor, and you might be subjecting them to extreme amounts of questioning, extreme amounts of, they might have to go through a deposition, be deposed. They're going to have to answer a tremendous amount of questions in terms of written discoveries, interrogatories, requests for admission, requests for production. They're going to have to potentially search through their emails. Every time that the survivor ever mentioned the plaintiff's name, they're going to have to turn over those documents. And it ends up becoming a really expensive process in multiple ways. It's expensive because attorneys need to prepare for those depositions. And if any of you have worked in a clinical setting and gotten the chance to work on these depositions, you'll know they could be really rewarding when you get the information you want. But it takes a tremendous amount of time, and lawyers, we are not cheap people, right, in terms of affording us. And in part, that's the cost of law school is really expensive. We put 3 years of training into just getting this degree, and then we have to take a bar exam. So it's expensive to hire an attorney to go through the discovery process. It's also expensive on an emotional level, especially in this particular context. So we have this problem where the law is not set up to quickly dispose of cases, no matter how frivolous they are, in this Me Too context, in this he said, she said context of cases. So I work with women to try to avoid defamation claims in certain ways. Like I'll suggest sometimes I'll work with somebody and I'll say, what is the purpose of the story? What do you want to get out there? Is it your experience? Is it to bring your accuser's name, or not your accusers, to bring your assailant's name to light? And sometimes you have people who say, I don't really care if the world knows his name. I want them to know my story. And so I'll say, okay, I'll make some suggestions. We're going to take his name out. Because then you're not going to meet the of and concerning plaintiff element of the defamation tort. Or we'll say, if you don't have factual evidence to back this one particular part of the story up, and you don't think it's necessary to include it to get to the purpose that you want to tell your story for, let's remove it. And I feel at my heart, guilty sometimes when I advise that, because I believe these women. I believe they're telling the truth about their stories, and I have no interest in protecting the perpetrators. In the same sense, my goal is always to ultimately enable somebody to tell their story, but do it safely. In different states, this is a lot easier. And so I live and I work in North Carolina. I'm actually barred in North Carolina, South Carolina, New York, and New Jersey. So for those counting at home, that's a lot of bar exams. And I hope you don't have to take as many. But in North Carolina, we don't have what's called an anti-SLAPP law. We also don't have this law in South Carolina, this anti-SLAPP law. And so there are some states that have these anti-SLAPP laws. New York has one, it's very weak, and we're going to go over it real quickly. But in some states like California, they have these mechanisms in place, these laws, that basically say, if you bring a frivolous defamation suit, then as long as you're not able to basically win it on this initial stage, this what's essentially like a motion to dismiss stage, if it's a frivolous suit, and we could see that this is a frivolous suit that's just brought for the purpose of silencing the survivor, of silencing the defendant, then we're going to throw the suit out within 30 to 60 days, depending on the state, and we're going to make you pay the other side's attorney's fees. So we stop discovery until we rule on this motion to strike that's brought under the anti-SLAPP law. But basically, there are some states that have these really great laws in place that are aimed to actually protect the defendant, not the plaintiff. It's not about giving the plaintiff their day in court, because there's a recognition that sometimes people abuse the system. In New York, you can only use the anti-SLAPP law if the speech at issue was made during a public meeting. So if you're in New York, unless you make a public accusation unless you make an accusation of someone in a public meeting, you don't get to file under their anti-SLAPP law. So part of my goal in my efforts to help women, it's to defend them and to make sure they're able to come forward safely, but I'm working towards adopting or enacting an anti-SLAPP law in North Carolina as well. And I know there are a lot of efforts in New York where people are trying to strengthen the anti-SLAPP law. So there are ways in which legislatively we're able to potentially help women to get their voices across, especially in this important context. And I think that we need to be really conscious of those efforts. And to the extent that it's something of interest to you all, I encourage you to look into what those efforts have been in your state, because these can make all the world of difference. If you have a law on the books that enables women to throw out defamation suits that are brought frivolously in the context of sexual assault, sexual violence, sexual harassment, then you're going to be able to ensure we're going to be able to help a lot more people come forward and do so in a safe way. So I bring that up as a positive note to end on, that there's hope that in certain states we're going to get these laws enacted, and you're going to see a lot more people feel comfortable speaking out about their experiences. But until then, I advise people to take things out that it's tough, and I don't mean to, but I'm very grateful to get to do the work I do and to be able to help protect women in coming forward with their stories and coming forward with their experiences, because again, women's voices are really important, especially in this context. So I'm glad to be able to help people be heard. Thank you.
Thank you for that presentation and for ending with a call to action and optimistic note, which is always appreciated when we're talking about such difficult topics. So I think now we are ready to go to our final presenter for panel 2, Professor Demleitner. So I will hand things over to you.
I hope this works now. Can you hear me? Excellent. Thank you so much for bearing with me. I think this is Apple's sign to me to really invest in a large new computer. So my apologies. I will turn our topic, yes, a little bit again, and Sam will be kind enough, I hope, to run the PowerPoint. Thank you so much. So I am looking at basically the decade we are in, and the decade that ended with suffrage, and went a little bit beyond that. And my focus will be on sex work. And Sam, if you don't mind switching to the next slide. I think what's become very clear, if we didn't know this already, that voting rights certainly did not mean equality for women. And so the question really is, how do we get to gender equality, to gender equity? But also in some contexts, what does it even mean? And this becomes really important as we're looking at this question of sex work, where ultimately I think we'll have to make some very hard choices about what it means to have gender equality. And my conclusion will be that what we really need to get to true gender equality is broad structural change. And in that way, I think I really tag on many of the prior presenters, especially from this morning, very broad economic changes to change some of the foundations, but also other areas where we need this change. But so let's start from the beginning. Sam, suffrage was actually closely tied to questions of immorality and sex right from the start. Let me remind you that 1920 didn't just see the 19th Amendment, it also saw the Prohibition Amendment. And the Prohibition Amendment was really an outgrowth of progressive movements to make people better. But part of this also was this notion that we can control morality or immorality, depending on how you saw it. And clearly, sexuality was a large component of that. So really where we are, Sam, in 2020, we are looking at some of the same questions, or we're in some of the same situations, let me put it this way, that we were in 1920. And I'll tell you why. Sam, we've all heard enough about the flu pandemic of 1919, and obviously we know about the current pandemic. But what you may not be thinking about is the influence and the impact that COVID-19 has had on sex workers, Sam. And there are no really good pictures of sex workers, or better, the absence of them in the United States. So I pulled these from Europe, where some major European cities basically shut down their red light districts. We'll get to why they allow organized brothels, basically. But lockdowns require that they shut down. One of the most famous ones in Hamburg just declared bankruptcy because customers would not come. It's not totally a luxury item, but it's not a necessity of life that one frequents a brothel. And therefore, many of the men, and this is still a very gendered, not solely gendered, but a largely gendered profession. So many of the men just stayed away, and presumably will stay away till the pandemic passes us by. Now, 1920 was slightly different in the sense that it wasn't so much the flu pandemic, what I can tell, but much rather the problems of venereal disease that came to a head during World War I that really triggered the control, regulation, and oppression of sex work. But what we're seeing basically is women who have lost overnight their livelihood. There is no social support network for them. There is no unemployment benefit that they can receive. They basically can either endanger their lives now by going out and trying to find the rare customer. Some apparently have turned to phone sex, or they can stay at home and try and somehow make life work. So we also know that these problems fall disproportionately on some women rather than others. Sam, if I could get the next slide too. So sex work, as I already said, is highly gendered, but it's not just highly gendered. Many of the same disproportionalities that we see in other areas where it is poor people who do work that is much harder, more physically demanding, often more demeaning, and certainly lower paid. We see this replicate in sex work. So there is racial differences, obviously huge class differences, and also increasingly the awareness that especially transgender, transsexual women are at great danger and are really the most mistreated, the ones who have kind of the hardest position in life. Probably disability, certainly mental health issues also play a large role. There are huge studies on that that really come from Europe. What we're also getting the sense already is this great danger in which many of these women constantly, even independent of the pandemic, find themselves. Violence is often a part of their job, and so is police harassment. It's criminalized in the United States. So really at any point, women can be picked up, even if they don't actively prostitute themselves, but give the appearance of soliciting. Now, interestingly enough, we have on the one side this criminalization of sex work. And on the other side, we have met the woman who kind of gets trapped in the system. If we could see the next slide. And the next few slides will tell you that this is not new at all. But you've probably all seen kind of QAnon, the conspiracy theory in which some right-wing activists engage, focusing in particular on sex trafficking and pedophilia. Now, they see it as part of a large conspiracy of liberal forces. Probably many people think this is crazy, while other people believe some of it, believe part of it. What it is definitely not is new. Sam, if we could see the next slide. Some of you may have seen these before or heard about them. White slavery was a rallying cry really from the late 1900s to the mid 1920s. It was tied, Professor Johnson started talking this morning or talked about anti-immigrant sentiment. It was tied into a very strong anti-immigrant sentiments. The traffickers, at that point they were white slavers, were largely portrayed as European men, usually Southern European or Eastern European men who would lure these innocent girls really into debauchery and prostitution. I'm using the language from that time. But if you're updating the language, you see many of these same parallels. Interestingly enough, also, there were always allegations of widespread governmental corruption that was involved in these slavery rings. So we see quite parallels here between this portrayal of some women as kind of these innocent victims, while other women are clearly the ones who are already language of that time kind of quote unquote damaged. Now, what that turns over is major legislation. Sam, if we could see the next slide. In the 1910s, it becomes the Mann Act, which is a result of really an international, or I should say a European American, and this also involved Latin America, movement against these white slavers. What you end up with is incredibly selective enforcement, initially against immigrants, but then it turns also to enforcements against African Americans. Now, you may think, oh, well, the enforcement is directed against men. Well, yes and no. Of course, men were the original target of this. But funnily or interestingly enough, many of the women who were involved in consensual relationships, either with that particular man alone or with multiple men but were not forced, were also charged with a violation of the Mann Act, really as accomplices to their own defilement. This was a clearly kind of way to go after political opponents, to selective people who they saw as undermining public health and public morality. If we could see the next slide, because I have some legal language for everyone here. And what we will see is that the White Slave Traffic Act from 1910, better known as the Mann Act, and current federal law are not dramatically different. The for any immoral purpose language is taken out because that was the that gave the government the ability basically to go after two unmarried people who had a consensual relationship, but that was immoral at the time. But if you're looking at some of this language today, I think it should immediately jump out that it is very broad. In fact, it is quite overly broad, and it has striking similarity to that language from the past. And it really replicates this notion of some women are good, some are not. Now, if you're looking at how we kind of really play with these words of sex worker or prostitute on the one hand, and sex trafficking, we only need to look at the next slide, which has Jeffrey Epstein, the most famous of any, I think, of the people who were initially charged 15 years ago with sex trafficking. What does he plead to in state court is prostitution. Now, we all know that, well, he wasn't convicted of it, but certainly there's enough indication that rape sounds like the crime with which he should have been charged. And neither one of these other two offenses. So certainly this has nothing to do with prostitution at all. This is not the only case. Sam, if we could see the next slide. This was in the news for a short period of time, but some of you may remember this. Robert Kraft and the Day Spa. And even when you look at the Daily News headline, what does it say? Faces prostitution rap, and then right below it says human trafficking sting. Well, I think we're thinking two very different things right now. Prostitution, this is an old man going to have sexual relations for money with presumably a younger woman. We may not like it, but it doesn't sound like he's an abhorrent human being. Sex trafficking paints a very different type of offender and a very different type of situation. Short end of that story, Robert Kraft got everything thrown out on Fourth Amendment grounds. The women involved were prosecuted. In fact, if we're looking at the next slide, Sam, we will see a highly gendered enforcement, not surprisingly. If you're looking at the bottom line of the arrest charge, the only offense where we see many more women arrested than men, quite disproportionate. The male number is largely pimps and johns. What we also see is a dramatic downturn, however, in arrests during that time frame. That is probably largely due to the greater use of the internet. People meet in different ways now. There's different controls, and much of sex work has moved indoors, which makes it slightly harder and more time intensive for police to investigate. That incidentally also makes real sex trafficking much harder to detect. I don't mean to give you the impression that I think there's no sex trafficking out there, but I do think we're currently overplaying how much there is, and we're also really fudging categories. Now, criminalization also has an impact on men, Sam. Male customers, for lack of a better word, were, especially in the late 90s, heavily prosecuted. The notion was to shame them. What that, however, meant for them was usually not a criminal record. It meant to be informed about women's rights, to learn about why you shouldn't be frequenting sex workers, and ultimately their records were wiped clean. But the shock should have been that you saw your picture in the morning paper, and so did your wife and your neighbors. Now, all of this has led to calls now for sex workers' rights. Sam, we could see that. It's largely about protecting women better, allowing them to protect themselves from violence better and against police harassment, giving them some kind of access to social safety protections. So this leads us to the final question, which is, what are the options? Now, the great thing about that chart, Sam, is that all of these options are currently in play, and they're actually, we can see how they work on the ground. The most famous was probably the Swedish option, the Nordic model that's now been adopted in many countries. Decriminalize the women, criminalize the male clientele of the women. Well, there's problems with it, and we can talk about that, but that seems the most progressive kind of equality type model. The flip of that is the Dutch model, which went to total legalization, which is either hailed as women have a right to choose whatever job they want to take, or it is hailed as the most abject oppression of women that we could possibly have legislated. We, of course, have, for the most part, with the exception of a few counties in Nevada, this total criminalization model, which really does nothing but harm. If we could look at the next slide, this is this whole fight over what is true gender equality. So here'd be my mantra and my suggestion. We really kind of struggle with what this means in this context and what women should be allowed to do. But I think our first role, the next slide, please, Sam, is that there should be no harm. And currently we're actively doing harm to women. And we're doing it especially to women who are different from those of us who are sitting in front of this Zoom. Poorer women, women who don't have a lot of options, women who have drug addictions, women who have often were institutionalized either in institutions or in foster homes as children and then kicked out at 18. So really we're talking about women who don't have the abilities in terms of maneuvering life that we have. So we cannot do any further harm. And this is my deadline for 2030. We can't wait 100 years to stop doing that. And then I think the next one is we have to do good. That is much harder to figure out what exactly that is. But certainly the number of women currently engaged in sex work in the United States is much too large. And we need to be able to give women other opportunities in life than to pursue that line of work. Thank you.
Thank you for another excellent presentation. Thank you to all three of our speakers for your wonderful presentations and work that you're doing. I found that each of your talks really spoke to each other in some thought-provoking and surprising ways. And I thought I'd highlight just two themes that I thought ran through all three talks before turning to some really engaging questions we have from the audience. So I noticed that in different ways, all three of you spoke about or referenced the dominance of white and male voices and perspectives and the ways in which law is either leading or sometimes lagging efforts to prioritize the voices of women and girls, which would lead to sort of more empowering choices for women and girls. And I also was reflecting on the question that we heard earlier today to Professor Banks, where someone asked her for advice to current law students for what to do sort of for current law students who care about women's rights in the next century. And I thought that each of the three of you really spoke directly to specific areas of activism that need attention. So I hope that everyone finds some answers to that question in our three speakers on panel 2. So thanks again. And with that, I'm going to turn to some questions from our audience. So the first one is for Professor Thompson. So do you think the victim blaming narrative, as seen in the Montana comment to the mistake of age defense, speaks to a broader narrative that decenters issues of race and gender in preference for a focus on, and here the author actually wrote air quotes, so I'm air quoting, in preference for a focus on personal responsibility?
I think so. So the comment that I highlighted from Montana, you know, what I think it reflects is this attitude, this traditional attitude, and I don't want to generalize, but I kind of feel this way, among men, that there is a such thing as a teenaged kind of victimizer, right? A teenager who is really an adult and who has bad intentions and who seeks to take advantage of a man in some way. And so that's what I see reflected there. And that's why I said that even if we're talking about jurisdictions where there is not a mistake of age defense available, that those attitudes might play into, say, the decision to prosecute at all. So I think that there is some impact there. On personal responsibility, I think that that's really interesting. I've been thinking a lot about whether teens ought to have the capacity to consent to sexual activity, particularly with other teens. Is there, the fear of exploitation? I don't know, does it go away when we're talking about two 16-year-olds? I think it might. And so we allow children to do all kinds of things that are adult activities, right? They can get hunting licenses. They can, a girl can get an abortion if she wants to. So we have to, I think, loosen the reins a little bit, because it is what we kind of see underlying this regulation of teen sex is this idea that it is immoral to have sex, and that there is this parents ought to have control over the decisions that children are making at this age. So I think there is a tension that's there, and that's something that I want to address in the piece too.
Thank you. And I'm going to pick up on something that you just said and reframe it as a question to Professor Demleitner. As you just made this, or you raised the question of whether teens can consent to sex. And I think Professor Demleitner's presentation invokes a question of whether any women can consent to sex work, or whether it's inherently exploitative. And I wanted to ask her, if you read Slate or other popular news sites, you're certainly aware that some individual women find sex work empowering. And so I'm wondering, how does that play into a discussion when it's phrased more broadly? Can sex work be empowering for women? And if so, then that leads to some different legal choices on that scale that you laid out in your last slide. How much do we listen to the voices of those individual women when thinking about a more structural question about women and sex work in general?
I think it's really important to listen to them, because I think this is really a topic that is very hard for people necessarily to kind of share that sense and to fully understand what women are going through. And I think it's a prime area where it is so easy to make laws from a desk without understanding what is really going on the ground. I think the same questions kind of come up with who are the men, why are the men, what are ways to kind of really address kind of the underlying demand. I mean, one of the questions is, really what comes first, right? Do you go after the supply or do you go after the demand? And we certainly see this when we're talking about drug offenses now. And we've tried to go after the supply rather than to deal with the demand. And so I think we're dealing with the same type of question here. But personally, I think we need to move towards at least the decriminalization model. With all the problems that decriminalization models bring, I mean, there are always limitations that are built in, which means you still have a black market that develops around that. But certainly what we currently have is we have both state power and private power that are pressing down on these women. That is the biggest problem. And I think that's what any of the women involved in sex work are complaining about the most. And I do appreciate the fact that there are women who find it empowering, in part also because the rest of our structures are not equitable. And if you are looking at kind of the pay equity discussion we had earlier this morning, or lack of pay equity, we see jobs that are require stringent hours when there are childcare demands on women. Lots of women in sex work are talking about greater flexibility that allows them to accommodate different parts of their lives. It's easy to poo-poo that if you don't live that life.
Thank you. And in keeping with this theme and focus on women's voices and silencing them, sometimes I want to turn now to a question for Professor Ligon from the audience, where someone asked, on the subject of silencing or quelling the speech of survivors, what is your opinion regarding the use of NDAs in sexual harassment settlements? Do you believe that these should be an option? Should survivors have the ability to bargain their silence, or is the public/third-party interest in transparency and knowledge of dangerous individuals in positions of trust more of an important interest?
That's such an excellent question, because as a First Amendment advocate, I'm somebody who always believes more speech is better, and more information and more access is better. But I think in these really personal contexts, people's situations, it's a fact by fact analysis, and I don't want to force anybody into speaking out when they don't feel like that is in their best interest for whatever reason. It's not typically that I feel that way because, again, it's not about the perpetrator's rights. It's about somebody who has their own story to tell and should be able, in my opinion, to do it on their own time. And if it's not something that they want to come forward with for whatever reason relating to their mental health or their spiritual health or their physical health, I want to ensure that we're not putting anybody in danger. That being said, I worry very much about NDAs, especially when it comes to the disparity of resources. And are we forcing people into choices because they are from a lower income background? And so that's a concern as well, because I want to ensure that it's not just the voices of people who are wealthy or who have a ton of resources that are able to come forward. It should be everyone. So I don't have a great answer other than a very lawyerly one, which is I think it should be on a fact by fact basis or case by case basis. But I generally speaking would lean towards allowing women to make those decisions for themselves and giving them the autonomy to decide when and if they want to come forward with their experiences.
Thank you so much. And with that, I want to thank all three of our panelists. I think we're going to wrap up here 1 minute late, which might make us the most on-time academic symposium ever. So thank you everyone for being sticking to your time limits and having such wonderful presentations. And with that, I will hand it back to Sam.
Thank you, everyone. I'm going to put you back at attendee status for the last few minutes. One moment. Okay, we made it. That was fantastic. Thank you, everyone, for coming today to learn and engage with us. Thank you to Wilmoth, Maher, and Deutsch for your generous support, and to all of our co-sponsors for working to make this event a huge success. Thank you so much to all of our panelists and to Professor Banks for a riveting discussion of so many issues. And thank you to everyone who made this day possible. If you would like to read everyone's papers in full, I encourage you to keep an eye out for the spring issue of the Law Review. And a small piece of housekeeping, I'll be circulating a survey to everyone, so I hope you can give us some feedback on how you feel today went. And finally, I will leave you with this. We are currently in the middle of an election, one that ends in 11 days on November 3rd. And tomorrow morning, early voting starts in New York. In honor of everyone who fought and died for our right to vote, and for the millions of Americans who are unable to vote, I urge you to please get out and vote. Thank you so much, everyone. I'm feeling very grateful. Please stay safe and stay healthy. Have a great weekend.